Good morning, everyone. This is the August 23rd, 2018 meeting of the California Board of Occupational Therapy. Welcome. I'd like to call the meeting to order and ask, our secretary, Laura Haith, is not here, so I've asked Sharon Pavlovich, our vice president, to take roll.
Okay, Beata?
Here.
Denise?
Here.
Jeff?
Here.
Laura is absent. Sharon is myself present. Richard?
Here.
Okay, we have a quorum.
We have a quorum. Thank you, everyone, for coming. Thank you to our guests as well, and thank you to the webcast. We also have some staff here. We have our counsel, Reggie Pejuhesh and Lorraine Marks. We have Jody Casada, staff, and Jeff Hansen. Heather Martin, our executive officer, is quite ill this morning, so she's not going to be able to join us. This is the first time she's missed, apparently, a board meeting in her time here, but she's quite ill. So Jeff is here in her place, literally, and also to help us with some issues that we may have for informational type things. So thank you, Jeff, for filling in for Heather.
No problem.
As a result, we may occasionally have some questions that need to be taken outside the meeting for a later time, but we'll do our best. I would like to invite the members of our guests, here for public comment or to observe the meeting, to introduce themselves if you wish. It's not obligatory.
Sure, thank you. My name is Heather Kitching. I am the president of the Occupational Therapy Association of California and a license holder, proudly.
I am Kristen Neville, State Affairs Manager with the American Occupational Therapy Association. It's just in the neighborhood, but I've got mine.
Welcome. Well, thank you for coming. Just on a comfort note, we did get some water here, so maybe we could take just a quick minute to distribute that. Oh, thank you. Well, thank you very much. It's terrific. As for the remarks, I don't have any remarks other than the Heather Kitching, the Heather Martin absence. Do other board members have some remarks that they'd like to make today?
OTAC is coming up in October. There are several people that, including myself, are very grateful to be presenting, so I just kind of wanted to give a little plug and reminder to go out and come make a visit in October for OTAC and come visit for the sexuality talk and sexuality questionnaires, which I'm presenting, and a lot of different schools are present. So I just want to say thank you to OTAC for that, and looking forward to OTAC in October.
That's great. Thank you. Anyone else? We're also, that's at the OTAC conference, the annual OTAC conference, and we're also doing a presentation for the Board of OT for licensees, and many students come to that as well to learn about licensing before they have their license. So, so that's. But I went to Sharon's presentation at AOTA conference last year, and it was great. So, very highly regarded.
Thank you.
Are you able to hear? Good. Just checking. Technical note. All right. Public comment session. Moving on to item 4. Public comment session for items not on the agenda. Do we have any public comment? Nothing today? Okay. Thank you. Number 5 is the review and vote on approval of board meeting minutes. I believe that we have to double check some of the information on these minutes that came up during the review, and so we'd like to hold off on that till the next meeting. Have staff re-review tapes. Are there tapes or something? Yeah. And just go through and make sure that it's accurate.
Do you need a motion for that, President Bookwater, or is that just a suggestion, or how do we procedurally go about this to hold them off?
I don't believe that we need a motion to just, what
I think
what
you
do our
can-
council say?
I think you can push it over to the next meeting.
Right.
Yeah, yeah.
I would like to say before we move off of it, I really like the way that they put the votes and the boxes and the yeses. That was a new addition to our minutes. I think
Mhm.
it's very nice.
It's clear.
Yes.
Well, there's
All right, so we'll look at that next time. We also, for agenda item 6, we have review and vote on approval of the June 20th, 2018 special teleconference minutes. Do we have any, is that something we also need to, can we review that today, board members? Any comments on that?
I wasn't on it, so I was on the plane.
Oh, that's right, Beata and Jeff were not there. This is our special meeting.
We're okay.
The only I only had one
Sure.
question, that regarding the last two votes, specifically the voting that happened where there was a yes and then there was a no back-to-back was on the exact same wording. So for example, as I remember it, it was, the board will do this if to oppose, not, and then it was flipped to ask it almost the exact opposite way. So that's why you see the votes actually lined up the same, as I remember it. But perhaps we better listen to the tape on that one. It was the end of that vote, President Bookwater, it was the end of the vote. A motion was made, it went one way. Laura Hayes, board member Laura Hayes restated it, a vote was taken. But it doesn't, I don't think the notes reflect that there was two different.
Oh, I see. Well, so I actually, so are you referring to the last two votes or the one on the page 2? Or the,
I'm
or the
referring
both
to
on
the
the ones on
last
page
two
3?
votes on page 3.
This
Yeah.
is the way I remember it, but why don't we have them check it again with the tape? And that's certainly, if you feel that should be checked, we can certainly do that as well.
I'm not disagreeing with the outcome of the vote, I'm disagreeing with the context around it. There was some actual wording very specific to why one vote went one way and then why the next vote came back the other way, and I don't think there's a differentiation there.
So do you want to work with staff on that wording, or do you want to talk about it now?
I don't need to further talk about it now than to just either identify that issue. So if that seems to
I don't remember what that context was, but perhaps you can, talk to staff about it, yeah.
So how should we proceed, Jeff? Should that be one that it's just the one section of those notes that is out of, it's not everything.
I mean,
And
if this
the-
is
and the-
small, we could deal with it here, or else if you want us to listen to the tape, we can listen to the tape. But
Why don't we
I mean,
listen to the tape? Yeah.
Well, the vote is accurate. What is not accurate is the context in which it's written. It doesn't clearly differentiate the wording that took place. It was a clear vote one way and then came back with a motion. That's why the vote went the way it did. And there's no differentiation.
The first vote was on the legislation or the position of the board. The second vote was on the letter. And
Correct.
I believe that this reflects
Correct.
that. I don't see how this doesn't reflect that.
So this, Laura Hayes moved to support AB, these are the votes for that?
But as I say, if you have a question and want to have it reviewed, then we can certainly do that. We don't want to have an inaccurate record.
The inaccuracy of the record that I'm questioning, so I guess you do want to review it, is the context. There's a clear differentiation. You'll hear it on the tape. It happened back to back. It was rapid fire.
Okay, well,
And
let's
you'll
do that
see-
then.
you'll
Let's
see
push it
the-
off till next time.
Mhm.
Yeah. So we'll do the same with this. We'll review this at the next meeting after
And
staff reviews.
it's just the section on the letter, Jeff.
On this?
Yeah.
Okay.
That was on agenda item 5 only,
On 6.
5 and 6.
Mhm.
Both 5 and 6 have been requested to take a second look, or review with the tape. Any other matters on section 6 at this time? 5 and 6? give a-
They're on
Public
6.
comment?
I'm sorry, I'll try to be more clear about which item we're on, because I've been kind of just moving on to the next one without identifying each agenda item. So I'll do better with that.
Did we call for comment on those?
We did not. So for both 5 and 6? Do we have any, I forgot to ask for public comment on the items 5 and item 6. The board meeting minutes. Do you have any comment, Heather? Thank you. Sorry, I forgot to ask earlier. Are we ready to move on to item 7?
Yes.
Okay. So agenda item 7 is a discussion consideration of whether referred in BPC section 2570.2 and whether this pertains to a physician's referral. It is in light of some of the analysis, the proposed language of AB 2221, which removes the word referred. The question came up during the analyses about what the current language actually says. So we brought that language forward to have a discussion of the board regarding the use of the word referred in the language and what that means and how the board is interpreting it. So that's how this item came to be on the agenda. The materials in the packet show sections of show the BPC 2570.2 language around referred. Did people have a chance to review this language? So the proposed language in AB 2221 is at the bottom. In the middle it says existing language in BPC 2570.2. The practice, it said, shall I read it? I mean, is that helpful, do you think? Read it for the web. So existing law defines the practice of occupational therapy and specifies that occupational therapy services encompass occupational therapy assessment, treatment, education, and consultation with individuals referred for those services after diagnosis of a disease or disorder. Existing law prohibits a person from practicing occupational therapy without being licensed under the Act and makes a violation of that prohibition a crime. AB 2221 would instead define occupational therapy for purposes of the Act and would make conforming changes. The bill would also eliminate references to a referral after diagnosis in the description of occupational therapy services. Okay, so the existing language is under 2570.2K, says practice of occupational therapy means the therapeutic use of purposeful and meaningful goal-directed activities, occupations, in parentheses, which engage the individual's body and mind in meaningful, organized, and self-directed actions that maximize independence, prevent or minimize disability, and maintain health. Here's the sentence that has referral. Occupational therapy services encompass occupational therapy assessment, treatment, education of, and consultation with individuals who have been referred for occupational therapy services subsequent to diagnosis of a disease or disorder, or who are receiving occupational therapy services as part of an individualized education plan pursuant to the Federal Individuals with Disabilities Education Act, IDEA. And it goes on to discuss more about the definition of occupational therapy, which I think is not necessarily, it doesn't talk about referral any further. The proposed language in AB 2221 would alter 2570.2 to state that occupational therapy means the therapeutic use of purposeful and meaningful goal-directed activities with individuals, groups, populations, or organizations to support participation, performance, and function in roles and situations in home, school, workplace, community, and other settings. Occupational therapy services are provided for habilitation, rehabilitation, and the promotion of health and wellness for clients with disability and non-disability related needs, or to those who have or are at risk of developing health conditions that limit activity or cause participation restrictions. And then it goes on to discuss occupational therapy treatment or definitions, but there's no reference to referral in the newer language. So I think the The question arose, is this a medical referral or not a medical referral? I think was the question that arose because of in looking at this language. And I remember when the Occupational Therapy Practice Act was being discussed when it was being formulated back in 2000, and the idea of referred without including, it didn't say physician's referral, it didn't say who was doing the referring, specifically because of the wide variety of practice areas. For example, at the time, I was working at a adult day health center where, for an agency that had a multi-social service, a social service program, where elders live in the community, and they would live in not such small, crowded apartments, and would ask the occupational therapist, social workers would ask the occupational therapist to come in, perhaps, and take a look at, for home safety purposes. Also in ergonomics, where a person may have not necessarily have a health problem yet, or may have a health problem that could happen because of their workplace setup and repetitive strain, and the occupational therapist would be referred for an ergonomic assessment of the workstation by perhaps an employer or an HR department. So it wasn't necessarily, there may be a referral, but not necessarily a physician's referral or a medical referral, but there may be maybe a pain or a symptom. And there may be a diagnosis, and this interesting, it says subsequent diagnosis of disease or disorder. So
Does it also, President Bookwater, does it also indicate that by having the word referral in there, that it limits our practice in terms of direct access? Is that one reason this is before us to consider as well, or?
I think that, I'm sure that that's out there in the world, and that may be something that people are concerned about, why they're concerned about what this means.
Mm-hmm.
I've always looked at it as being, a person could one could present oneself as requesting meeting services. I get a client's daughter calling me up and saying, I don't think my mother's house is safe. Can you come and take a look at her house, for the home setup? And certainly her mother has diagnoses, but it wasn't necessarily coming through the medical system or.
The specific ask when this was put before the board, is there a specific ask around this from a group? Or is this for information only, or is there?
We have some public comment. Maybe we can clarify.
Sorry, but I spoke to Heather Martin about this last week or the week before, and she had communicated to me that this came from a concern arising from DCA, that they were looking at AB 2221 and noticed that the referral was taken out, and that they were seriously concerned that it was related to direct access, that would change physicians' ability to refer and everything. And her feeling, she explained to them that how the board had interpreted it consistent with what you've been explaining, but that's not how DCA was interpreting it. So her hope, she said, all right, I'll put it on the board's agenda, the board can go on the record, they can discuss it, and I don't know if she was hoping if someone from DCA would be here to hear the discussion, but maybe you all could discuss it, and I don't know if she was expecting to come up with a formal letter response or anything, but maybe just that the discussion is in the minutes and goes on the record, she could provide that to DCA and allay their concerns. And just communicate to them that how, in her, the way she was hearing what they're saying is inconsistent with the board's interpretation. That was my conversation with her. I'm not trying to put words in her mouth or anything.
No. Yes, and I believe one of the analyses of the bill included the word that stated that medical referral was being removed from the language from one of the committee's legislative analyses, and medical referral is maybe a little bit narrower, I think, than what I have been viewing referral here as. For example, the IEP, the educational referrals is talked about here. Although those kids tend to have a disability, it doesn't necessarily say a medical referral, it says a referral subsequent to diagnosis of a disease or disorder. So that seems to me a little broader than medical referral, but I don't know what other people think.
And that's a tough one.
I would want to include social referral, social services referrals, and is a referral by a nurse, case manager, a medical referral? Maybe it is, because she's a nurse. But how about an LCSW?
Yeah, I would think it would be any referrals from other healthcare providers.
How about a family member? If it's a referral from a family member, that's not a medical referral. Or a self-referral, if a person presents oneself and says, I'm having a problem getting around my house, can you talk to me about in my case, a power wheelchair or a mobility device? Sorry, I need a doctor's prescription. Well, under Medicare, you would. So it's a payer.
One of the biggest questions that we get from licensees is whether or not there does need to be a medical referral, any type of referral. And our common answer is, in private practice, somebody could walk in off the street, refer themselves, and the occupational therapist can provide those services. But we've always said that it's not likely you're going to get insurance reimbursement unless you do have a referral from a doctor. So, I mean, that's the way how staff has approached this question.
We've also worked with Rebuilding Together and home modification, which is where you work with a contractor and you're referred by the Rebuilding Together group, and it's not really a medical thing, but Rebuilding Together helps modify people's homes that are in disrepair, but also may need some modifications for normal aging population, ramps or railings or grab bars in a bathroom. And those are referrals from an outside non-medical agency for people who typically do have a diagnosis of disease or disorder, but who may not have been referred through the healthcare system. So I thought our wording was open to that, of the current language.
Yeah, me too. But I'm not sure where the power lies in kind of the interpretation of, by deleting of what that might infer. Is my question.
Well, I think I think the interpretation, if I had to break it down concretely, first starting with direct access, we don't have direct access in the state of California. So to believe that this wording gets you there is a stretch. We also know with the evolution of healthcare, I can tell you in August, just this month, this is when all the health plans tell you what they're going to approve for the next year. And the word that's out there right now, at least in the Medicare market that I'm in, is that social determinants are going to play a huge role. So to Richard's point, those referrals, social determinants means a person has asthma, to keep them out of the hospital. Remember, I work for a company where we look at full risk and all of those things, where it's the bottom line. So they have asthma, so they can go for XYZ treatments or 10 visits to the urgent care center, or the insurance company can put the right kind of air circulation in their home. That's where insurance companies are going. And they're going to need occupational therapists to help them in the safety of that. So I think those referrals aren't just going to be coming from physicians. Even though we know someone else might say, I want to access occupational therapy, we know in order to do that, we have to get a physician authorization. And so I think it's a little bit of a stretch right now to say it's that black and white in this wording, that we would infer one thing or another. I'm not getting that, is my take. I mean, I think it's out there, and I think that people would try to infer that, but I think there would be clarification on it, and this would be, whatever our vote is on this, if there's a vote, would be on tape, that, healthcare is changing. These referrals are coming from everybody. People are going to pay for these services. They're going to refer themselves. So we have to be ready for where the future of our practice is going, and not, not just focus on things that are old school like direct access. old terms.
To the point of the question of whether this pertains to a physician's referral, I would, if we were to have a vote on it, I would say no, because it does not say physician's referral in the language. It doesn't actually say anything about who makes the referral in the language, so to be so specific as to say that it's a physician's referral, I think would be, is not supported by the language in our current bill, and I would take that position that the current language does not say it has to be a physician, that it's a physician's referral specifically.
I would agree with you on
Mhm.
that, Richard.
Me too.
Do we, is it,
You wanna say anything?
would it be fruitful to have a motion to that effect? Is that,
That word for just not.
what is the board's thought on having a motion to that effect? Stating it.
Well,
Is it
I could
necessary,
int-
or are we just having a discussion?
I can attempt to make a motion and you can tell me if I'm right or wrong.
Do you think we
Wanna do
need
that?
one? Do you think we need one? What do you think? What the council, what do you?
Just to clarify existing law?
Well, I'm not, see, again, Heather's not here to talk about the context, and I don't know if we need to take an official position on this in terms of a motion,
That's a
or
good point.
if this is simply a discussion, an informational discussion.
I do.
It doesn't say potential, I'm sorry,
No.
it doesn't say action, right, on this
Right.
one?
It doesn't, and to the
Discussion
point you
and
just
consideration.
made, because it was brought forth by Heather, not to keep deferring things, but it does seem fruitful to have her specific input based on the discussion with TCA, perhaps before we take action.
My question is, since we don't know whether she'll be well enough to attend tomorrow, can you defer this till tomorrow to get a clarity from her why she put it on here? And if she isn't here, then you can defer to a future meeting if you need to?
Oh, that's a good idea,
I
yeah.
think
That's a reasonable idea, yeah.
Clear with what the discussion with the item is about, referred to in section 2517, whether this pertains to a physician's referral. I mean, it sounds like you all are saying this does not pertain to a
Right.
physician's
Mhm.
referral.
Which is,
Yes.
So just in order to clarify where we are now and what may be discussed tomorrow, because I'm not sure if the public will be here tomorrow as well, is that what I understand, the summary of the discussion is that the change that's proposed in 2221 does not change what was required to be a physician's referral to now no longer. That is not, it wasn't required then, and it wouldn't be, that requirement is not being removed.
Can't be removed because it wasn't there in the first place.
By 2221, is that
Right.
correct?
That is,
That's with the discussion, that everyone is in agreement that it wasn't previous, a physician's referral was not previously required, and so it's not being removed by 2221?
that's correct.
Okay. So, I am not sure what motion, what action the board would be taking as a result of that. So what I understand Mr. Farrer to be recommending is that if the executive officer feels like she needs a motion to clarify a board's action or a board's not policy, but interpretation, then we can ask tomorrow and hold this over. And then you can ask the public whether or not that, they have any comment on that way in which the board is proceeding. So.
That's exactly what. That sounds reasonable to me. Anybody have another opinion?
no.
All right, well, that's what we'll do. We'll hold it off and see if further action is needed at a future meeting date tomorrow or the next meeting. Thank you. Oh, yes, so public comment on that, please.
I would just like to say I appreciated both the president's comments and Ms. Miller's comments, to it not being position referral related. I just agreed with all those comments and appreciated them being brought to the fore. I do want to mention that OTAC had a chance with our lobbyists from Capital Advocacy to talk to the DCA directly about this exact topic a week or two ago, and what I shared with them I'd like to just share briefly with you all, which is I agree with Ms. Miller, the future, we should be ready for the future. But my concern about this sentence in 2570.2 largely is where it goes on to say, subsequent to diagnosis of disease and disorder. I'm not sure how legally that would be interpreted in certain situations, those being all of the political practice I do. I mean, I actually work with Native American tribes in the state of California to move their sovereignty agendas forward through the use of occupation by mobilizing community groups like the youth on the reservation and that kind of work. So I do a lot of social, politically based practice. I just built a whole fieldwork situation with the Long Beach Boys and Girls Club where the club didn't know what OT could offer. But we went in and pitched a program situation where we could bring in fieldwork students and offer a lot of programming they didn't have the money to pay for themselves, but certainly the clients they serve, the young people there needed, and so we did it. So in those scenarios, that's an OT kind of hanging a shingle, so to speak. You know, that's an OT, there's no self-referral, there's no referral at all. That's the OT saying, you seem to have a need, I seem to have the skills to meet that need, let's have a conversation, and then we build. So in that sense, in terms of envisioning the future of practice, it's the other part of the sentence that concerns me, not necessarily the word referred, but where it says subsequent to a diagnosis of disease or disorder. On the flip side, by the way, I think if there is a medical diagnosis, there certainly should be a medical leader involved. I mean, I do understand situations that do require referral and oversight by another kind of expert, you know, if someone's had a stroke or whatever. But there is a whole world where there's really no referral of any type. And that's just the future I'm concerned about, and I would hope we would continue to consider. Thank you.
Thank you. Other public comment?
The only point that I would add to what I had said before is something that you all hit on already, that when I talked to Heather about this last week or a couple of weeks ago, she told me that she did explain to DCA that removing this language from the OT statute does not prevent the insurers from requiring a referral, if that's what DCA's concern was. So she did convey that, make that very clear to them.
Thank you. And I would add to that that working for Kaiser, which is a large health system, we have internal policies that require a physician's referral for our services within a healthcare organization. So it's more, and because Medicare and healthcare regulations, it's a highly regulated industry, and they are more, they have a tighter referral set of referral requirements than the language that we seem to have in our law. But there are different payers and situations, as we discussed. Is there any other public comment on item number 7 or board? Any board comment further? Okay. Are we ready to move on to item number 8? Discussion and consideration of whether the clinical internship experience completed as part of the Doctor of Occupational Therapy degree program is considered practice, and further discussion regarding OTD programs in California that are not accredited by ACOTE, the Accreditation Council on Occupational Therapy Education. The issue here is that there may be there's sort of a misalignment in what's happening in our regulations, so we wanted to look at this. The issue, as stated here, is there are individuals who, after completing the entry-level education requirement, currently MSOT or similar, enter an OTD program. As part of the OTD program, Occupational Therapy Doctorate Program for people who may not be familiar, as part of the OTD program, individuals must complete a clinical internship, residency, or fellowship. These individuals self-identify as doctoral student or grad student in the clinical setting. Question: how does this activity relate to 2570.4 of the OT Practice Act, which is shown here in the materials? Is the clinical internship, residency, fellowship considered practice by the doctoral students? Do these individuals need a license for services they render in the clinical residency, fellowship, internship? And what impact is there, if any, if the doctoral program isn't accredited by ACOTE? So the relevant language is follows in BPC 2570.4 talks about BPC 2570 talks about who the occupational therapists and occupational therapy assistants need to be registered, need to be licensed. But there's a section, this point 4 says, nothing in this chapter shall be construed as preventing or restricting the practice, services, or activities of any of the following persons. A, any person licensed or otherwise recognized in the state by any other law or regulation when that person is engaged in the profession or occupation for which he or she is licensed or otherwise recognized. B and C are the relevant ones. B, any person pursuing a supervised course of study leading to a degree or certificate in occupational therapy at an accredited educational program if the person is designated by a title that clearly indicates his or her status as a student or trainee. And C, any person fulfilling the supervised fieldwork experience requirements of subdivision C of section 2570.6 if the experience constitutes a part of the experience necessary to meet the requirement of that provision. And then there's a D as well. Any person performing occupational therapy services in the state, if all of the following apply, they filed an application with the board, the person possesses a current active and non-restricted license under another state, and they have 60 days, they're performing under another occupational therapist for no more than 60 days after they've filed their application. Occupational therapy services are performed in association with an occupational therapist licensed under the chapter and for no more than 60 days from the date on which the application for licensure was filed with the board. And then a person who is employed as an aide subject to supervision. And then the BPC 2570.4 C talks about, refers to section 2570.6, which states an applicant applying for a license as an occupational therapist, or as an occupational therapy assistant shall file with the board a written application provided by the board showing to the satisfaction of the board that he or she meets all of the following requirements. That the applicant is in good standing and has, that the applicant is in good standing and has not committed acts or crimes constituting grounds for denial of a license under section 480. B, 1, that the applicant has successfully completed the academic requirements of an educational program for occupational therapists or occupational therapy assistants that is approved by the board and accredited by the American Occupational Therapy Association's Accreditation Council for Occupational Therapy Education, ACOTE, or accredited and approved by the American Occupational Therapy Association's predecessor organization or approved by AOTA's Career Mobility Program. So the crux of this issue is that, for example, when I was an occupational therapy student getting my master's degree, I had an internship, as all the therapists, therapy practitioners do, and you're working on, you have an internship of 6 months, 3-month internships, and you sign your notes, you provide services, you sign your notes, Richard Bookwalter, OTS. You're working under the license of the precept of your supervisor, and you're covered because you're in an ACOTE accredited program, and that's how it was in the old days, or during license. And now we, as follows here, we see that some of these OTD programs, none of the OTD programs is actually accredited yet by ACOTE and so they kind of fall. All of our regulations refer to someone practicing as part of an ACOTE accredited program, but the OTD programs aren't accredited yet, and so they don't fall under that. Some of these provisions that say that talk about that, but they are presenting themselves as occupational therapy interns, resident students.
Can I add to that, Richard?
So yeah, please.
Yeah, and I think some of the discussion too, Richard, came from, so now that we have residencies and fellowships, when you have a normal clinical or internship, usually you're done, and entry-level students can apply for boards, they get their license and they practice. Well now, when you have a residency or fellowship, they can still sit for boards, practice, but now they have a year residency or a year fellowship. So for consumer protection, it's like, I'm in a doctoral program, so I'm actually practicing student, but I have a license because I just passed boards, but I'm doing residency for a year post. So for the what's your heading? Do you qualify? And because we don't have a standard from ACOTE for entry-level doctoral programs, that's confusing. You know, when you're trying to explain that to the patient, or, you know, I'm a resident student in a doctoral program, but I have my license so I can actually practice. So how does that affect billing? How does it affect your documentation? That, I think, too, was another question that they had when we're looking at standards, when we're looking at regs and consumer protection. That was something that fell into the same discussion.
Well, yes, and also our regulation says that you could practice under occupational therapy services are performed in association with an occupational therapist licensed under the chapter for no more than 60 days from the date on which the application for licensure was filed by the board. So if these residents had applied for a license, they could practice for up to 60 days, but that's not how it's structured.
No, it's for like a year.
They're going for a year and they don't apply for licensure. They're just in that status for a year, but it's not an accredited program. But at least the OTD program is not accredited. Now, my question of Heather, when she brought this up to me and we discussed putting it on the agenda, is generally these programs are accredited as master's programs, or they are accredited under, but that OTD program is not accredited. And does that count? Is that good enough, or is that not good enough? And I don't know the answer.
That's what the question is for when somebody graduates for the programs. I think Loma Linda and USC have the post-professional OTD programs. The big question is, once they graduate, for the people that haven't gone on and passed the NBCOT exam based on the master's degree, do they get to call themselves a student? And technically, they wouldn't fall under the exemption that's provided in 2570.4 B or C, because they're not enrolled in an accredited program. The OTD programs are not accredited, and those two programs are not accredited, and then we have several others that are in the process of being accredited. So that's the question. That's the problem that we're running into. I mean, it's a real life case that we're having questions posed whether or not they should have a limited permit to work in that capacity, and limited permits are only issued for a short period of time. And if somebody fails the exam, I don't really know what happens to them in the OTD program at that point, but I mean, that would seem to be a problem if you can't pass the entry-level examination and you're out there providing services under the guise of an exemption for students. I don't know. I mean, that is a weird kind of situation.
When we were talking about AB 2221 with the Business and Professions Committee and the AOTA and OTAC, one of the concerns of the staff, the committee staff, was that if we're not necessarily in the business of accrediting program, we don't regulate necessarily education programs. So if they're being regulated under A code or under the education program, then there would be a handoff, and then after that status is over, then they fall under the board's jurisdiction. But we're not going into the schools and trying to regulate that. But if they're not falling under they're not regulated by A code and they're not regulated by us, that's the situation that we have right now with these people, it seems like. And that's how I'm conceptualizing it.
Yeah, so I think Heather may be looking for a way how you would perceive this, or?
Well, I have a few comments, if I may, and
Absolutely.
I would like to back in to my questions about, really my questions are going to end in what is the board's authority, which I think there is some authority. But I'd like to, if I may, first start as a dues-paying member to an association. I'm going to put that hat on since we have public members here from our association. Because I think what is important to put into context, especially for our public members who aren't on the blogs and don't follow all of this, but if you look at the timeline of the decisions and discussions, I want to end with the fact that I'm very happy after Mrs. Toad's wild ride this summer with A code about single point of entry. That's a fair way to put it, right? Starting in June and ending in August, that we have come back. The A code made a decision to go with a single point of entry, and then early on, or they made it a while ago. We've been moving in that direction. As a disclaimer, I don't have a doctoral degree, but as a dues-paying member, I support my profession and the leadership in the direction where they were going. And if that was the way they were going, I would certainly get that doctorate, and that would be that. At the end of so I really don't have a strong opinion one way or another. Should it be single point, should it not? Because I'm so far into my career about are we viable? Are we getting reimbursed? Are we getting all those things that I frankly, on the front end, having the discussion long and long. 4 years, I think, to exact that ACODE has discussed this. Can you tell them a little, as a dues paying member, a little bothered how long they've discussed it? 4 years to discuss single point, not single point. So the point being is that meanwhile, I'm in a field where I see nursing and social worker who I love working with day in and day out, bypassing the field of occupational therapy in the aging population, getting direct referrals for care transition. For example, if I may, I will stop on these comments, but you opened a juggernaut.
That's fine.
With this, and I will back into what is the board's authority. But essentially it goes like this: as a dues paying member for over 25 years who loves both of my professions, state and national, I guess what I would say to you is when I go to the table of a coalition on caregiving in Los Angeles, and we are putting together a survey with every system there is, Kaiser, Ultimed, who I work for, the county, big key stakeholders, and the survey is including questions on ADLs and independent ADLs, and they don't, top of mind, think an occupational therapist should be qualified and including that as part. They didn't say we weren't qualified. What I'm trying to indicate is we weren't the first go-to person. Nursing was in social work. So have we lost our way 4 years? I don't want to throw everything out. These are great people. They're my colleagues. They've done good work. But let's get more current. The leadership made a decision. Stop messing around with, now we have a new board and they want to go back and discuss it. Let's look to our history, how long people discuss the MBCOT. Let's not lose ground on this. Let's not lose ground, because those of us who are practitioners get nervous every day when someone else gets a referral that we should get. So that being said, I would then put my hat on as a board member, take my blood pressure, now I'm calmer as a board member, kumbaya, done talking as a practice association, dues paying member who loves both associations, and I'm active. But as a board member, I would say this, so clearly, if you want to know the truth, I think the board has the authority to go back to ACODE and put a time limit, asking them for their timeline on when they want to get this up to speed, so that we as a board can make a decision on should this qualify as someone who can sign or not. Clearly, from consumer protection, the hat we wear here, it does not. It's clear to me. It's clear to me. And it's not my fault that they spent 4 years talking about 1 point of entry or 10 points. But as a board member who is tasked with protecting consumers in the state of California, quite frankly, I think our position before us is to take action on what we might work with our colleagues on who have that authority to help them to get current. That's all I have to say.
Okay. So that is relevant to the fourth question in the set of questions that we have. That's highly relevant to the last one. What impact is there, if any, if the doctoral program isn't accredited by ACODE? Because if they were accredited by ACODE, it would be a moot point, right?
If they're not,
but they're not. So that's the issue that we have,
yeah,
right?
So my statement as a board member, I don't know where the rest of my colleagues are. It'd be great to hear you on that, but I think it clearly indicates that they're not compliant. And so to make, we will work with them and lock our, but what's before us is the protection of the consumer.
I agree with you. I agree. I don't know how other board members feel.
I agree.
Yeah.
That's what our mission is here.
Right.
Not on helping the association change anything. It's about.
So backing up, extrapolating from that, or backing up from that, I'm kind of going up the up the questions from the bottom up, because we have 4 questions. The one was, what impact is there if it's not accredited? Since they're not accredited, do these individuals need a license for the services they render in the clinical internship residency fellowship? To me, that suggests that the answer is yes.
Yes.
They need some form of a license. You suggested earlier the wording limited license. I think that could be something we would look for as a board. specifically what that speaks to, what I think you were going to, Richard, is there needs to be some regulatory oversight of anyone who's touching consumers who are receiving services of occupational therapy.
And by extension, the only way to do that is to have some kind of license, right? Yeah.
Some sort of
Some-
oversight.
Because the license.
Yeah,
and-
because it's not gonna happen that fast where it's black, and we have to join forces with our, but I do think we have to put a statement out there to them to get them moving.
So can I just make a clarification too? We have to consider too, there's entry-level programs and post-professionals. Post-professionals come in already licensed. Okay, so
Right.
that's a new point. Entry-level is different. They can have a degree in any area and then go through a doctoral program. So I just want to make sure that we're clear, because there's different levels of doctoral programs. Post-professionals are coming in as professionals, right, taking their doctoral degree. They already have a license, so they can, in theory, treat.
Sure.
But that, not for entry-level, right, because they're coming from,
Well, I think that's what the issue is.
Is that
It's
what the issue is?
post-professional, yeah. They've graduated, they can take the test, and whether or not they decide to take the test right away, or they're working in either, I think they call it a fellowship, or their residency in the OTD programs without having passed the exam.
No, but that would be their entry level. That's entry level, because post-professional is somebody you're already
I
an
know we're
OT,
talking about the OTD
masters,
students. I
you've
know-
got a master's, you're already licensed, and then you go in, then you get a doctorate.
For those that are, for those that have passed, but a lot of what we're running into is commonly the USC or the Loma Linda students that's graduated and has, I guess they can fast track into their OTD programs.
oh, yes, entry, yeah.
And they don't have the licensure. They're in the process of still taking the
Oh,
exam.
they haven't passed, or they haven't taken the
And
exam, they
they're
go straight into
then
the
going
program.
and
Oh, I
doing
see.
the residency and.
Okay,
So
that's
they
different.
But right, and I have had students like that indicate to me, but they told me, the student that I had, the doctoral level student, told me she had a limited
Permit?
license.
There would be a problem there with that. They would be falling under the limited permit category. That's also only valid for a very short period of time, so somebody would need to get in there and take that test right away. I do think USC has a requirement that somebody gets in and takes the test right away.
Before they let them register for the,
No, I mean, they get a fast track into the program. I guess once you complete the master's program, you can automatically enroll in.
And I thought it was that you had to, for post-professional, you had to successfully pass boards before you were going to
You
your.
know, they all have that as a requirement, but it's, again, that fast track program, and they allow them time to take the test. I mean, they're in the program pretty much right away from the time that the master's degree is completed, and I think that's really where this issue is kind of coming
I
from.
also-
It isn't, if I may, in a point of clarification, isn't what's the most simplest piece of what's before us is if they have a license or do not? Not whether they're entry level, not where they enter, that's for ACO. What's before us as a board is, do they have a license to practice occupational therapy?
Well, there is one other question that I had reading about the ACO materials, and that is that there are different stages of accreditation. There is candidacy, there's pre-accreditation, there are, the different stages, and I don't fully understand the different levels of accreditation, and is a partial accreditation or, considered accreditation under, could that be, we say accredited education program. So that seems black and white, either it's accredited or it's not, but there are actually degrees of stages of accreditation, and that our laws our regulations don't address. But also, I also don't know what that means.
I think there are some programs that right now, there's students that are enrolled, and the school would be accredited by the time that they graduate. I mean, you're going to run into that situation with some of those. So I can't really tell you either about the accreditation process, but I do know that there are students right now going in OTD programs with the plan that the school would be accredited by the time that they graduate. Then they can obviously sit for the examination.
can I ask an ignorant public member question? So if I remember, at some point in time, all you needed to practice as an OT was the Bachelor's of Science, correct? Or BA?
Or AA.
Or even an AA as an
As an
OT.
assistant.
Oh, as an assistant, yeah, but I'm talking about on this, to get to the doctoral.
Okay.
So when we talked about post-professionals who held a license, there are people holding a license out there. What would they need to do to participate? Would they have to first complete the master's program and then do the doctoral program? Or would they be able to, on this fast-track program, jump right into it and move for the doctoral program? I mean, that's as you continue to change the the goalpost, and you have people that are, permitted under one facet, what does that do to them, and how does that impact this entire thing as well? So, not only might the entry-level persons who jump into a fast-track situation, we talked about, well, that may not apply to post-professional, but if the post-professional is a BA or BS graduate, how does that impact them? Do they have the skills necessary to move right into a doctoral program? They do?
They do, because they
But
graduate.
with all 52 states now being licensed, correct? Doesn't the board don't we, our board in our state of California, at least for the schools in the state of California, we certainly want to work with our colleagues. I'm not trying to do a this or that. We want to get there. But does the board have some authority to put a question, a request, a statement back? Because
I'd take it one step further, or a condition. You want to ask questions and suggestions. I want to know, can we make a condition? You cannot move forward with your advancement unless you close these loopholes that we have to address for our consumer safety. That's it. I mean, that's what we're here to make sure, that they don't keep moving in a way, because they want to move it, that it ultimately impacts the consumer safety, and we're allowing them to do it. And so I think we should see if there's, I guess legal would be the ones, do we have the authority under our charter to sit there and say, don't move until you have a solution for this for us, and then what is that solution, and do we accept it?
And start thinking about licensure, A-code. Start thinking about licensure, since every state's licensed. I would say when A-code is coming up with decisions, they have to factor in what this would mean to a license in a state as well, and make recommendations back to the license boards in all the states.
But prior to a condition being made, it's almost like we have to do a needs assessment of what the school's already doing. If
Right.
everyone's playing differently, then we kind of have to, I don't even know if that's under our purview to ask what's happening at the school level. What is, USC doing, Loma Linda, and then get all the information before we go anywhere.
I agree with Sharon that we need to figure out this together, because it's a new situation for all of us. And even if we decided today that we were going to establish a new license category, it takes, it would take years to get that to happen, and we don't have we need the information for that. There are maybe some workarounds. For example, if these students were part of an accredited program at the school, then they would be covered under A-code, and then maybe not. The schools, there's some potential workarounds. There's some if we were to develop, if we were to extend the 60 days to a year, that would be something that we would have to consider doing. Or if we don't want to do that, then we could establish a new license type, which would take a while to pull together, and then also, or that they could be folded in. Once the schools become accredited, it's a moot point, or the programs become accredited, it's a moot point.
And in the interest of
Do you
being
think?
collegial
Yeah.
as well, I see where you're going. I don't see us having to do any of that. I see the A-code having to do that. I see that the universities would come before. We have criteria. Are you accredited or are you not? We could take action. If you're not accredited, you sign as an OTS. Whether you're OTD, a master's is irrelevant to the protection of the consumer. We could. I'm not proposing that, but let's start there. If that was one position, that's the language before us, then could there be a call to action to the universities to come before the board to work with us on where they might go, so that the consumer's protected, and we're also trying to work. Do you know what? I don't think we can be gray on this.
Well, I
just
think
don't.
There also, what we're not talking about too, is everyone's in a dual process of accreditation. So since we're going single point of entry, we have a date of 2027, and various schools fall into different accreditation years. So they're getting accredited for a master's now, but they're also shortly thereafter have a goal for the entry level. So there's all these different caveats that schools have to follow right now, which is amplified with dual accreditations happening. We're going to get this in 3 years, but we have to look at this in 5 years. So looking for something singular that's going to make sense right now is going to be really tough from ACO, just saying, because they're planning for this scaffolding to occur over the next 10 years, and so everyone's falling in different places. I think Samuel Merritt's the only one that has, and then the University by Guy McCormick that's opening up. His will be.
That's Yeah, it's called Pacific, University of
Yes, Pacific University. So I think there's only going to be 2. So just throwing that out there.
Well, I mean, technically, we could demand that these people be licensed or show how they are licensed or they're an accredited program, but we may not fully understand the A-code accreditation process. So it might be good to send something to the schools and try to see if they are actually in compliance somehow that we don't understand. Like maybe the schools are registering them in a master's program. We don't know, for sure. So, I mean, it seems to me that rather than that sending a letter to the schools would be helpful because there are a number of people in this situation right now.
So the call to action under that scenario, let's keep going with that. The call to action would be for the board to go out to the schools and ask them how they manage this, their interpretation of this. I don't know what the wording is.
Well, I think that we could explain that students are only allowed to practice under A-code accreditation, and to ask them if there's,
How they're addressing that.
and to tell them, to inform them, because I think they may not be fully aware of this issue. It's a little bit complicated, and to let them know that their students need to be somehow. Maybe they need to get their license. Maybe they need to take their exam and get licensed, or get a limited permit or something. Fall into somewhere before they can do these fellowships.
Can I ask you a question?
And bring them into compliance.
Of our enforcement team, right? Because ultimately this boils back down to a supposable that there's going to be some consumer harm. And then as a result of that consumer harm, there's going to be an investigation. And during that investigation, they're going to expose the things we're talking about today. And what would make it better for a person who does enforcement to say, if they had done this would not have occurred, or would have minimized this occurrence. So that's why I think it's really important for the people that are doing enforcement who would have either a real life example of where it's already impacted us, or a real deep concern of where it could be going. We're coming from a different perspective. I don't think, although all of you are in here, none of you are probably in the doctoral program right now. You'd probably be very competent to practice as you've got the additional education necessary. But that's kind of where I'm thinking is what was our enforcement team, such as Jeff and their team out there, their concern be, and how do you think that the board could resolve some of this?
Well, we've run into a real life situation like this, and there is the particular section that was cited to us was the exemption. I'm working under the exemption provided in 2570.4. At that point, I mean, we're kind of back and forth, telling them that you're not your OTD program is not accredited. Yes, the program that your master's that you completed was accredited. You need to get in and take the examination. I don't really know where the board wants to go with this. I mean, making somebody take the examination before they start a residency in the OTD program, or just by virtue of them calling themselves a student and not saying they're a licensed person out there. That's something too you may want to consider. But the case, we resolved it. I mean, we actually ended up approving the student, but there are going to be, it was a very small period of time, but we're going to run into a case where somebody's just going to say, I don't want to get in and take the examination. I can work as an exemption as a student all the way through until I complete the program. And how, I don't know how this particular case that may come up in the future, that person may be calling themselves an OT, and we're going to have a real problem with that.
I have a problem right now listening to it.
Yeah, it's a problem. We have our regulations, and they are in place, and even if we were to want to change them, which is not certain, it would get a couple of years before that could even happen. And so we need to bring people into compliance. I remember when the board first started in 2000, there were a number of people who didn't get licensed right away, even though they're supposed to, and the board really worked to get them into compliance rather than coming down with a huge, coming down with a hammer. You guys worked to get them bring them into compliance and get them licensed. And I think we need to me, I would like to see us work on something like that here, which I think a letter to the schools. What do people think? What do you think, Denise? What do you think? A letter to the schools and say, this is the rule?
What's your process? I'll let you get to the information.
And then We don't have the names of all the students.
Well, I think,
the only way to get to
you
the
know,
students is through the schools.
And I think, so to your point, I think it would be a good move for the board to write letters to the school following this discussion that said, look, this is the situation that's before the board.
Yeah.
This is what we do, and we would like to begin a dialogue. We would like to, I don't know what the exact wording of it is, but in the interest of helping them to get where they need to go and also staying true to why it is we're on this board, I think we have to take the lead in beginning that dialogue.
And I think we need to tell them that the students may be out of compliance with the law, be even more, a little bit more, more upfront about that, because it's not
And
even.
they have to be tasked, not,
Exactly.
our laws are clear.
Because they know who their students are, and they
Right.
know who's got a license already and who's in an entry-level program, and they're not regulated by us, so we don't know who those people are. And I'm sure nobody wants the students to be in violation of the licensing laws. Schools don't want that.
How difficult, I know you talk about having a whole new regulation and stuff, but modification on number, D3, where you brought it up, I thought it was an interesting opportunity to actually create a situation where somebody could, under the rules, participate. Could you sit there and say that it's 60 days unless, of course, they are entered into a doctoral program that could be extended to a period of time? And would that help with public safety again? And, but then it would be a student, it wouldn't be a OTD.
Well, I think, yeah, clarifying that you can only represent yourself as being an OT if you hold a license. I think we're all clear on that. I think everybody agrees.
Or it gets extended
And if
to
you don't have that, all you can do is represent yourself as a student. I'm sorry.
No.
I agree.
Yeah, or we could extend it from 60 days to a year or something if you wanted to do that, if it's a year long, if that's the standard.
But
for
I'd
these
only want to do that for
residencies,
folks that are going to move to the next step of wanting to have the doctoral program.
in the event of okay.
But again, to Sharon's point about how everybody's at a different level of accreditation, it doesn't hurt us to ask the universities to give us their suggestion. We have the clear law.
Yeah.
It doesn't hurt for us to have them come back and say it should be 30, 60, 90, involve them in the process. There's no harm in that piece and then voting on it, but so if you're looking for definitive pieces, I do agree that a letter should come from the board. At least that's my position. When you're looking for, I do think it's at least important what you stated about being very definitive in that letter about what's before us, clear on if you're licensed or you're not, and then thirdly, asking them to be part of the solution with us, because I do think by October we have to have some action on this item.
Yeah.
That would be my
October
take.
agenda, I agree. We should put it on the October agenda, and between now and October, do we want to have a move to ask the board to write a letter?
Well, I think our action for today is to write a letter to the schools notifying them of this issue, also notifying ACODE that we've identified that their master or their doctoral program residency issue is creating an issue for our licensing.
Right. So 2 letters, one to the schools and one to ACODE.
In that letter to ACODE, if I may just restate, I think it's important to ask them to consider, and because we are moving and evolving as a profession, now that all 52 states are licensed, it would be great if every part of their dialogue was a consideration of how this would impact license. Any decision they make, how does it impact the practitioner's license in that state?
Would you like to work with Heather on that letter?
Whatever pleases the board, whatever's helpful.
So we have a few ideas here. One is to write a letter to schools, another to write a letter to ACODE, and then to put it on the October agenda to consider any responses to the letter or for further action. Do we have a motion?
I'll make a motion.
Jeff?
I'll make a motion that we send letters to both the schools that are providing OTD programs as well as ACODE, the concerns of how the program currently is structured and the challenges it creates for their students in being non-compliant under our existing regulations.
Do we have a second?
I'll second.
Okay, let's take roll. Beata?
Yes.
Oh, no. Oh, public comment?
You need to
We have,
ask.
Board
You
discussion?
should have
Board
additional
discussion?
board discussion, and then you must call for public.
Yeah, so we have a
comment.
motion and we have a second. Do we have any
I did want
further?
to make sure that we asked them for their feedback and assistance in solving.
I'm
this.
sorry, did I cut you off in your motion?
Yeah, but
It was
that's-
getting a lot, like a,
Yeah. Well, just make sure that we,
I got
in
it.
addition, I don't want it to just be that there's a problem and not ask for their assistance. in
would
the
you like to
solution.
review the letter?
No, I don't need to review the
Okay.
letter, but I think the executive director and the president of the board can sufficiently.
Open to
review that.
discussion. Do you want to restate your motion?
No, I think that the understanding as well, that it should be more than just that.
Okay. We have a motion and a second. Any other board discussion? Public comment?
No, I don't have anything. Admittedly, I've just started with AOTA in December, so I'm coming in on the tail end of everything that's gone on with the A code discussion and the multiple point of entry. The only thing I can say is that I don't disagree with Denise that this is something that ACO does need to keep in mind, that licensure boards need to be in the loop and involved, and they need to, it's a consideration that they need to take into consideration. And if there's any way we can facilitate, let us know.
Just speaking as a license holder, not as the OTAC president, I've had many fieldwork students over the years, I've had many residents over the years, and almost all residents I had were that fast track, so to speak, type. So they were in that weird gray area. I'm actually, from a consumer protection perspective, I think this discussion made me proud of this board, to be perfectly honest. I think it was licensure board work at its best, what just happened. Because from a consumer protection perspective, it's black and white to me. You're licensed or you're not. And what I mean by that is all the other people in between also get confused, like the people supervising the resident, the manager over everybody, the student, the resident, the staff. Because it all gets very easily confused all the time in the throes of how busy the day-to-day work and practice is, to me, it comes down to your license or not, because the license holder needs to know he or she is responsible for whomever, the resident. And then the other thing I would just add to that is I would often remind my colleagues where we had a lot of those fast track residents, I would very often remind them that we needed to contextualize in our minds that the residents, even once they were licensed, we would go through that weird fall semester where they kind of weren't. That's what Jeff Hansen was describing. But even once they were licensed, I would say to the staff, remember how we treat brand new staff versus experienced staff. We don't just send them off and with a hope and a prayer. We're very rigorous about check off lists, and you will show us again you're competent. Even if you just did your field work with us, you're now new staff with us as a resident. So licensed, yes, great that you're licensed, but now we need to take you through that same list of, do you know how to review the chart? Do you know, whatever it is, you know what I mean, for that practice. So keeping all of that in mind and the complexity of all of it, you're licensed or you're not. A license holder has to know he or she is responsible for whomever these people are at whatever stage. So thank you for having a thoughtful discussion.
Thank you. Other public comment?
Maureen would like to say something.
No, Reen.
I just wanted to clarify something Mr. Farrow said, and I have a question about something that's in the materials. I think you talked about post-professional being post of BA or BS. And I think it is defined in reg as post-professional education training means education and training obtained subsequent to the qualifying degree program. And I believe the qualifying degree program is a master's in OT, is that correct? Currently?
Or, yes.
Licensure?
Currently, yes.
Yes.
Right, so the qualifying degree for licensure is a master's. So I think post-professional would be post-master's in this definition.
Okay.
And then I wanted to throw out there, and I don't know if it actually impacts this discussion at all, is that the exemption from licensure in 2570.4 talks about the practice in a degree program that's accredited. It does not necessarily tie that to the degree that is required for licensure. I'm not entirely sure how ACODE is set up, but there's a potential, I suppose, that they could be accrediting OTD programs, yet that's not what is required for licensure. I'm not sure, but I want to throw that out there, that there seems to be a difference between an accredited program, potentially, with the degree program that's required for licensure. So you could potentially have an accredited OTD program, yet it's still only required to be licensed at the master's level. Does that make sense? And therefore, somebody could be in an accredited OTD program and be exempt.
An unaccredited OTD program?
No, once it's accredited.
So you're right, Maureen. A student in that situation would be exempt under the law. They're in an accredited program that's designed to be able to take and pass the examination.
Well,
So the OTD
they
program,
could, they could be potentially in an OTD program that is accredited without being licensed.
Correct.
Because it's now leading to a degree that's an
Yes.
accredited program, yet they're beyond the requirement that's needed for licensure.
I agree that the issue is it accredited or not accredited? And I'm sure some of the schools will say,
Right.
but they're in our general program, our MSOT program is accredited, but the OTD one isn't. So I'm sure we'll get some of that feedback.
Correct,
I
so
would
somebody
expect.
has already
But
gathered
technically,
the sufficient requirements that they need to get their master's. They haven't yet gotten licensed. If the OTD program is accredited, I believe that the exemption would still apply the way it's written, because it just refers to an accredited program, not necessarily the one that's required for licensure.
so the schools may have responses along
They
those
may,
lines.
but
which
I
we
don't
can hear
know
about.
exactly how ACODE works, and I don't know if they'd be accrediting those OTD programs as a move toward requiring licensure at the OTD level. That I'm not sure of. So I want to throw that out there. And I just wanted some clarification on the materials. It says the status of California schools accredited entry-level OT programs. Now, does that mean, is that specific as to OTD programs?
Yes.
Okay.
Yes,
Because
that was a
thought
question I had written as well
Okay.
for Heather, but she's not here. But yes, because we had this discussion before putting this on the agenda, and it took me a while to get at all the complexities of this issue. But yeah, this is only
The OTD,
the OTD
programs, yes, because I read that and I thought that
right.
can't be right. Okay.
Right. That's a good point. I'm glad you brought that up. I'm sorry, Denise.
Well, all I wanted to say upon listening to Noreen's, and if there ever is a panel convened with the universities, I would love to sit on it, because this is very clear to me. I have very clear, and what's clear about it to me, because the law is clear on this, and so what's clear to me about this is if that OTD student, if their school is accredited as a master's level, and they went on to the OTD program that's not accredited, but they want to sign their name as an OTD, then they're out of compliance. If they want to take their license as a master's student following that program where that program is accredited, they go and take the MBCOT exam, they apply for licensure under that, then they can sign their name, and they can sign OTD candidate. Whatever it is they want to do, they have to be clear in that disclosure to the public in 12-point font and all of those crazy things around that. But that
I think you've outlined a very
yeah.
potential solution.
But so what I'm saying to you is it is very clear to me, so
Yeah.
I would be happy to be on the rebuttal team.
Great. Any further board comment on Jeff's motion and Denise's second? Hearing none, let's vote.
Okay. Beata?
Yes.
Denise?
Yes.
Jeff?
Yes.
Sharon? Yes. Richard?
Yes. Motion carries. Thank you for the robust discussion. Now, at this time, I'd like to have a break. Before we do, though, we have a couple of new public members. I just wanted to give them an opportunity to introduce themselves if they wish. It is not an obligation, but
Mike Chisar, California Athletic Trainers Association.
Nice to see you.
welcome.
My name is Alejandro Villanueva. I'm a occupational therapy student at Foundation Maintenance.
Well, great.
Okay.
Welcome.
Thanks
Welcome.
for coming.
Thank you for coming. At this time, I'd like to call a break. It's time for a break. 10 minutes. Meet at 11:05 if that clock is accurate. A little more than 10?
No, 10 is fine.
10 is good. 10 is good. Some of us need more time. I'm talking about myself. Time to restart reconvene our meeting after a break. We're the California Board of Occupational Therapy on August 23rd. Item number 9 is where we are at this time. Discussion and possible action on legislation impacting the board. There are 7 bills here that the board has been, some of them the board has taken positions on, and that have been progressing through the legislature with different developments happening. I'm not sure, though, that we have current versions of all the bills. Are you familiar with any changes in some of the bills since?
I am not, I'm
okay.
sorry.
All right. Jeff is not familiar. Heather was checking on that, but and I've checked on it some of them. The first page in the packet includes the legislative deadlines and important dates. We are tomorrow, as you can see, the floor session happened this week, August 20th through 31st. The last day to amend on the floor is tomorrow. And the last day for each house to pass bills is next Friday, August 31st. And then there's final recess, and then the governor makes his considerations in September. Just to remind people of those dates, there is a chart for the board meeting where the bills are summarized. Thank you to the staff for putting that together. Just reviewing what that says. I was reading the bills, but
Since we have a representative here for what was before us with 3110 that wasn't in the past,
should we take that one first?
It'd be
You're thinking of
awesome
taking
to-
it out of order, yeah, so that we can.
it'd be
Yeah.
awesome to hear from.
Yeah, that's a good suggestion. Mike, since you're here for the athletic trainers, perhaps we should just change the order of business in this item to include, to discuss AB 3110 first. Yeah, that makes, thank you for that, Denise. That's good, yeah. So let's move to
Yeah.
item 9F, AB 3110. So the board has taken a position of oppose unless amended on this bill. There is a letter. Sorry, I need to locate that.
Is it under F?
Well, yes, yes. So in our packet, we have the August 6th version of the bill, and a document that says amendment mock-up that is dated August 10th, and a letter from Carl London to Marina Espinoza, an email that included Heather Martin on this bill. And then also our letter, sorry, the first thing in the packet is the California Board of Occupational Therapy's letter from June 25th, 2018 to Kevin Mullen, Honorable Kevin Mullen of the State Assembly, opposing unless amended with the reasons, with several, the amendments, requested amendments and clarifications. Did board members have a chance to read this bill? thoughts? Let me narrow that down. Do you feel that the board's position is opposed unless amended? We have here the version from August 6th, that was dated June 25th, the version from August 6th that was read into the legislature, and amendment mock-ups.
If I may, just one comment to add, I stand with the board on oppose unless amended. I do want you to know that my particular vote on that issue is not to send a message that I'm against the athletic trainers developing their own board, which I'm not. It was against some of the areas that were left out, some that could be considered loopholes, some of the things that when they were going to come under us as a commission, we were looking very specifically at, like continuing ed and things like that, which I'm sure our public speaker will clarify. But I want to be clear that specifically my vote went that way, not against them as becoming a board, but specifically against some of the things that could now, that just need to be refined as a colleague.
Thank you, Denise. Other board members have any comments?
No, I think the biggest, if I recall the discussion, the biggest one was that we'd spent a lot of time trying to make a fit for the athletic trainers and recognizing some of the challenges of the language that was used, and there were commitments as that it developed to have that language changed, and it was surprising to the board when those changes that we had mutually agreed upon making,
right,
if you're going to be here, disappeared. And so it was it felt like, it seemed like, we raised them because we felt that there was legitimate conflict with the old language created, and to see it back made some folks a little disappointed. So that's why the harshness of our position is opposed unless amended.
There are two. Do you have? I was just going to say a couple things. I did a couple things. I looked at the language in the August 2nd and the August 10th documents compared to our letter. I found a couple of the things that we had talked about were still in the language. And then I also received an email from OTAC this week. The practitioners who are members of OTAC may have received, there's some information, new information about the status of the bill, and I may not be, I don't know, has the status of the bill changed? That's a question I would ask the members, the public members about. Is it okay if I ask for public comment at this time?
Yes.
Yes.
So I appreciate you having the bill. I appreciate all the work that you have done, and just to preface, many of the changes that were in the last iteration of the bill, and I apologize for not being here in May when you guys discussed that, were essentially foisted upon us by committee staff. And so we had taken virtually, in the original version of this bill, had taken virtually cut and pasted virtually every piece of language that you had suggested into the bill. And we did work in good faith with you. And the reason I'm here is I want to continue to do that. Personally, not to say it kind of negatively, but having you guys oppose unless amended stings a little bit. A lot of people oppose, and it doesn't feel quite the same. And I've got respect for you. And we had a legislator that voted against us, or that was silent in the first committee. I really respected her and wanted her to vote for us. Not that that vote made a difference in the final count, but I feel the same way about you guys. That if we're doing right by you and what your recommendations are, and that we can come to an agreement on that, that means we're doing the right thing. So yes, indeed, the bill has changed. It got stalled in the Appropriations Committee. So our very last step before the Senate floor, the governor, it died in committee on suspense with a number of other bills. The process is very political. It's So I think that's kind of what happened. It wasn't policy kind of approved as we went through. We had 3 different policy committees weigh in. It was at the Assembly Business Professions Committee that the bill that we said became untethered from each other. And it went to this hybrid form of registration. It wasn't registration really, it wasn't licensure really, it was somewhere in between. And I know on the Senate side, I know the DCA had issues as well with how it was constructed. So we used this time to work with DCA, to work with committee staff on both sides, and work with stakeholders on the language and kind of craft something that seems to be more workable and more implementable. I think that was some of the issue from the DCA end, that how do we implement was kind of, and they were trying to compromise and meet everybody's needs, and how that sausage making works sometimes. So I would anticipate some of the language, some of the key language to be the basis of moving forward, but I don't at this point know exactly what form it's going to take. There'll be meetings over the next few months, and we'll continue to work on it. I'd like to come back, as we get a little farther along, and I can share some of that work with Heather to share with you as we move through that process. There were a couple of things on your recommendations on your letter that I could go over those briefly, and see
Sure.
if you have any questions. In no particular order, the Con Ed, the way they constructed this is that people could still work as an athletic trainer. They couldn't need that title. So they couldn't mandate, I don't think, is what the intent was, that they could mandate continuing education for people who had no education and wouldn't be in those, be even allowed in some of those continuing education courses because they weren't certified. They weren't qualified to do that.
So the grandfathered people, kind of what, as we would call them?
Right, the way it was constructed kind of had this dual level for a large number of people. However, the requirement that people to call themselves an athletic trainer be certified, that requires us to do continuing education. That is mandated, 60 hours, including evidence-based education, evidence-based practice, is mandated, and you wouldn't be able to maintain a certification. So while it's not spelled out, and certainly we can look at spelling it out a little bit more clearly, I think it was in there previously, we'll go ahead and do that. Again, I don't know what form this will take, and if the broad grandfather that was included in there will remain or not. Certainly wasn't our choice, but to move the bill and at least get some public protection, that was important for us. Individuals, so in 3 and 4, you talked about advanced post-professional study and individual training and competencies. Going back and looking, especially at that individual training and competence, that strikes me as a little vague and a little bit of an overreach, so we'll certainly go back and look at.
Mike, can I go back and ask you a question about the fifth item on our letter, the continuing education requirement and the grandfathering? Is that you mentioned that might have been something added through discussions with the committee? Is that to not raise the bar too high for? Is that the legislature's point of view? Often is, you don't want to create barriers to entry. Was that the reasoning behind that?
It wasn't so much discussion as take it or leave it.
Well, yeah, no, that's a.
Yeah, so I think that was the intent, and there's another in the most recent amends. There's something in there to sort of keep. I thought it was already taken care of, but to deal with CSEA's union issues.
Right.
We created a long timeline, so they would have a chance change their name when they do collective bargaining.
Okay.
And so that was important to us that those people not be able to use the title because, as you were talking about earlier, the confusion that creates.
Thank you.
So certainly, again, when we look at those individual training or competence, that probably should not have been the way I read that now. So we'll go back and look at that as well. There was some concern about the illness in the prevention clause in the scope. Once we get a little further along, I'll come back. I mean, we provided some information about our education and training and kind of how that fits in. We certainly took illness out of the rehab area because we're not rehabilitating illnesses. But this is an area that our folks are trained and educated in, whether we're working in with a more general population or with a more athletic population. We're not the primary treaters of illness, certainly, but we're working with physicians on prevention, and whether it's things like obesity, certainly the things that are listed in there in terms of education programs and exercise programs are within our education and training. So I'll make sure that when we come back with the language, that's something that we highlight so you can see that. And then in terms of the clarification, so treatment plan, I can't remember if that got taken out. To me, it was sort of redundant, but I think that's also was DC language. So I don't have a particular huge concern about having that phrase in there. What's important is that I think there's a definition. And again, we had actually had a definition, and they kind of took it and modified it a little bit more of what a protocol would have. So we'll go back and look at that. And that we have Ledge Council also. We were talking to them more recently about that. And as a protocol, not as patient specific in a treatment plan, be more by referral from a physician and be more patient specific. And what that means, to me sitting here versus what it means to Ledge Council and legislative language in California. I mean, that's going to be advice that we would take. But certainly I would bring, all of this back when we have some language. I think we'll have discussions over the next couple of months. Even though folks are busy finishing up the bills that are kind of moving forward. But I will come back and certainly address kind of all of these point by point. I don't know if there are concerns now or things that I wasn't privy to that you also had concerns about from your last meeting where the letter was composed. And I must say it is helpful to have a letter that is specific as opposed to with suggestions in areas of concern. Because that's easier to work on rather than those for either no specific reason or just kind of very broad areas.
Well, thank you. Any other public comment from other parties?
Just to say that OTAC for many years has been in support of some sort of regulatory language to position the athletic trainers well relative to the protection of the California consumer. I mean, through this whole process, we mostly had concerns of language, scope. Anyway, we of course are equally interested in remaining collaborative to get things to where we all hope they be. So.
Feels like a safe space here. Not every meeting feels that way.
We're glad.
Andrew Gentler board. And occupation.
Mike, and thank you for addressing all those issues and going line by line. I can't imagine what that feels like when the bill's smashed and you're drawing back. I mean, the work we've been through having a conversation for several years now. So just sending words of encouragement, support, and hopefully looking at collaborating and what comes down the pike. So thank you for always being here and just having that dialogue with us. It's very appreciated.
Any other comment on AB 3110? Right. Hearing none, thank you. Thank you, Mike, for coming and updating us on that bill, and good luck in the future. Yes. Let's move to 9A, Assembly Bill AB 1659, regarding the inactive licenses. It was ordered to a third reading in June. Let's see the status of that. I believe the board supported that. Is this the one? Yes, the board supported this bill because it had the lower inactive license renewal fee, which we used to have until we were out of compliance, and then we had to up the inactive license renewal fee. But it doesn't. I don't see a change in our position, or personally, but I don't know if anybody else. It doesn't seem like it's progressed.
It hasn't changed in any way. That would undo why we supported it.
Yeah. Next, any further discussion on AB 1659 from the board?
No.
Any discussion on from the public on AB 1659? Okay. Hearing none, let's move on to AB 2138, Licensing Board's Denial of Application Criminal Conviction. This is a bill, looking at the materials. We the board took a position of oppose unless amended. There's a letter in the file in the board materials from June 19th, 2018 that the board sent to the Assemblyman Chu and Assemblyman Lowe, the authors of the bill. I'm not sure if all the board members have seen this letter before. Paragraph 2 of the letter talks about the concerns about how the language of the proposed bill would prohibit the board from requiring an applicant to self-disclose criminal history information in one of its sections, and would impose an impractical timeline for the board to render a decision. And on the second page, there were a couple of other items mentioned, which were some of the data elements and demographic information would be gathered under a future Breeze release, but might take some time to gather that information. And then second paragraph on the second page asked for clarity on replacing on the phrase substantially related crimes versus directly and adversary related, which was used in the proposed language. And the board's position was that we were asked to be excluded from the bill, because there were a couple of other boards that were excluded from this bill. Just to let you, basically, there have been some changes in the bill with regard to some of the language, but not all. And we have sort of, Heather, in discussions, found that the reasons that those other boards were excluded were because they had other regulations that were related to this, and that there's some regulatory and statutory things about those boards that was unique. Our board does not have. So the message was sent that we're not going to be excluded. that was sort of our position is not going to be adopted, that we should be removed. So I wanted to kind of go over the language There is, Heather included some of the language of the bill. So the four things that I talked about, the prohibiting the board from requiring an applicant to self-disclose criminal history, that's still in the current version of the bill. The timeline for the board to render a decision, it looks like, has been removed from the bill. The timeline,
To be honest with you, I'm not up to date.
I couldn't find, it looks like that's been removed. And then the board reporting requirements are still in the bill. And the directly and adversely related phrase has been removed and replaced back to substantially related, which it was before. So some of them have been changed. Two of the things obviously have not. So what are the board, and then if we wanted to, we have the opportunity to submit another letter with some concerns, again, if we want, or not. Or we can keep our position, change our position. There is an example here of the accountancy board and the comments that they made that were sort of item specific, and that's on aspects of the, and that's how another board did it. Followed at the very end of the section by a fact sheet that they sent in. So that was kind of an interesting format to if we wanted to share any additional concerns about this bill, or it's what another board has been doing. We've had examples from other boards during previous meetings. So I just want to open up discussion. Do we continue to be comfortable with our position?
I am, because everything's not addressed.
Okay.
Are we still at 2138?
We are.
Because I think we voted actually on, that motion didn't pass to oppose unless amended. It was to exclude CBUT from, that's the motion that's passed. And that's to write the letter that we're not gonna, that we're gonna support it, but as long as they exclude us. I thought that was the final verdict. So it wasn't opposed unless
I
amended.
remember it being that motion failed and that we had to vote to oppose unless amended to exclude us. Is that in the minutes?
To exclude us, yeah, so that's
So-
the one that passed, but I thought it was, yeah, this is the whole not clear part about
I
those
see.
minutes.
I see, yeah,
That's what I'm
yeah.
having issues with, because I thought that the whole opposition didn't work, and then we're gonna either support it as long as we're excluded from it altogether. That's was our final.
That was a recommendation of the legislative committee, legislative and regulatory. The legislative and regulatory affairs committee recommended that we support unless amended to exclude CBOT. And then when we brought it before the full board, that motion failed, and there was a second vote to motion by Laura, I think it was, to oppose unless amended to exclude us, to be stronger. And that was the position that we took, as my recollection, but we could certainly.
No, it's the
No.
opposite. I
No.
voted to support, and that was unanimous. The one that was put to oppose failed.
And then,
That's where we're having a,
and then the one that passed was the one that we're gonna support it as long as we are removed from it, excluded from it.
that's the, yeah.
So we're not part of that at all. That's the one that I
So
clearly
since they say we're not
remember
gonna be
that.
removed, then we can't support.
Well, this is the letter that we sent, oppose unless amended,
I
because
know,
of that
and
vote.
that's why I wasn't clear about that, because
Yeah.
that's not what we discussed.
Okay, so maybe, all right.
Exemption, take the board out.
Yeah, because I think both versions failed, right? The oppose unless amended, or
They
support
did.
unless
They
amended,
did.
oppose to the
They did,
compromise
but was
was.
Yeah, all of them.
unanimous.
We oppose unless,
Yeah.
we're removed, or support is removed, or something like that.
Yeah, but this is not
There's
clear, then
discussions
in
about
these
the
minutes,
particular
it's not.
authors of this legislation.
Yeah, in these minutes, it's not clear at all.
Oh, yeah, unless it excludes licensees from.
It excludes.
Licensees.
Yeah, it should be exclude. It says
Oh.
excludes, but it should be exclude.
Yeah, the OT, like altogether, the industry.
All right, so what are your, so we have some folks who would like to take a look at the actual vote or say that it was, I mean, I remember this to be the accurate vote, and we have people who remember it to be different. That complicates matters. If we were to take any action today, certainly that would probably be relevant, but be quite relevant. Or we could simply just keep watching it and see what happens. It's I mean, I don't know what to make of what to do with this. What do you guys? What do you think? Move it up to the next meeting. By that time, the vote will take
Is
place.
there
The vote's
really
taking place
next-
next
The
Friday.
sunset, it'll be.
Is there really an action for us to take?
That's the question.
That's
That's the question before the board. yeah.
Okay.
It's here and it's on the agenda. So if we wanted to take an action, we could, or we could take no action.
Well, the letter stands the way it's sent, even though it may be different than what we discussed here, which I know is a problem. However, they've already made it clear that we won't be removed, and that was the thing, whether we would support, we'd only support if amended to exclude us. So, I mean,
Are we comfortable with our? Well, it sounds like we're not comfortable with our position, but
well, I
which
don't know
thought
that
we
you
were,
can put
but-
that genie back in the bottle, other than
Yeah.
the way that you could send a letter basically just confirming we're unable to support unless you've removed us from it. We understand that there may be statutory and regulatory reasons that you have to exclude the other groups, but we don't think that that's a reason that you can't exclude us. It's a reason that you're choosing not to exclude us, not, you're not using an example of a reason that you can't, that you have to exclude
Do you want
us.
to take a pulse over
So,
Well, yeah. I mean, the other thing is, do we want to write another letter explaining in more detail
We don't
why?
have to.
Well, no, we don't have to. There is this. If we did want to, there is this accountancy. This is an interesting document. If we look at the last document,
yeah, it is.
where the Board of Accountancy, California Board of Accountancy writes, below are highlights of some applicants denied licensure that the board would be unable to deny under AB 2183, and it lists 1, 2, 3, 4, 5 applicants who had somebody like misdemeanor, so they wouldn't apply, but they wouldn't be able to.
I'm looking at, it's such a small percentage of those that were denied that had a criminal history. I just don't know what our denial rate is based upon criminal history. Do we have that information, Jeff?
You know, I don't, but I mean, it's pretty low. I mean, I think you have all used your discretion well. You've had cases that you really look at very closely. I mean, you've recently had some applicant cases that you've asked questions of the enforcement unit of. I think you have exercised your discretion the way how a public protection agency should. And this bill kind of takes a little bit of that away from you.
Yeah, it just doesn't let us.
I'm okay with the.
You're okay with? Can you speak up?
Oh, I'm okay with the way.
The letter.
Yes, the letter. I'm okay with the status right now.
Okay.
I don't know if there's a pulse or.
No, that's
People want to
that's
have more
good to know.
discourse or.
Does anybody else feel comfortable with the way things stand and not, just keeping things the way they are versus
Well,
putting in more info?
The issue that has risen on the difference of the letters is nothing we can fix, right? The purpose of some of those discussions were how the authors of the bill, who have a lot of oversight on other things that we're moving that are priorities to this board, could react, even though they should not be reacting based upon how our action is on a piece of legislation against something that we're trying to move or support. They should. But the reality is that was probably the guiding factor in a lot of the discussions that we had, realizing that there could be negative consequences to our decision to oppose unless amended. It was actually the same discussion we had about the athletic trainers, and there was a lot more, I would say there was a lot more passion in that one because of what we felt was the relationship we had built over time with them, versus this one, which was, we appreciated the idea, and we knew that the move, not just within this particular scope, but statewide, was trying to remedy people's ability to access the occupations based upon past prior activities that. So we can't fix that. I mean, we can't. They've read it. They know that this board came across it. If they're going to hold it against us, they're going to hold it against us. I think clarifying, if we have data to support to say this is why we think we should be opposed, that we should be excluded, because we've done a very good job of allowing those that we feel are, if you believe that data is correct, and I don't know because you settle so many outside of the licensures that, the overwhelming majority of those with a criminal background who have applied for a license based upon going through all the steps to a secure license have been granted, and only those that are an anomaly outside or of serious concern are denied. I think that's a good backup to sit there and say this is why, boards are in place, is that we can use independent judgment, and we're not abusing that judgment to just blanket deny people the opportunity to licensure, and that takes away our public safety responsibility to make sure that those second set of eyes and the third set and the 12th set of eyes, 15 set of eyes, are on this, and making sure that consumers are protected and Californians are protected. That's the only reason I would think that doing something just a snapshot as a supplemental, I don't know. You could do that.
Just your clarification, you're saying if we have the data to do something like a county did, would it be nice to follow up with that kind of letter? Is that what you're saying?
Yeah, just to update,
Okay.
say it there and say, I know that you come back and that you don't believe we should be excluded,
Okay.
but here's why we think it's good for us to be excluded. We've not demonstrated a rubber stamp of no's to anybody with a criminal background. However, we've been, because of our taking our role seriously in public consumer protection, there have been those that have raised serious concerns, and they have an appeal process that if they're denied, that they can have their day in court. However, we're not abusive, but you're taking that away from the consumer.
My question is, can they include us anyways, or can we tell them that no, that we don't want to be? Can we make them not put us part of it, or
No.
can they just do
That's
that?
what they're saying, that the other ones probably have regulatory or statutory language that allows them to do that.
Or that already maybe covers some of the items in this bill and supersedes
Yeah,
it, or.
and it was approved back
maybe
when there was a
more-
time where there was less of a, move to.
So that's
Can
not an
you
option for us.
restate-
Fiona.
Sorry to have you go back, I'm a little slow on this one. Can you restate where that information came from that they came back to us with that rebuttal?
Heather was asked to, it's the committee, I think it was the Business Professions Committee staff and the authors of the bill, and I'm talking to different boards. There have been a lot of different boards have been in discussion with the authors of the bill over this bill, and there have been some changes in language, as you can see, and I believe that it's that was conveyed.
So they came
That's
back.
that's not a change they're willing to make.
Okay, so they came back and said there's statutory reasons, so then
That's
with
right,
that
which we don't have,
information,
yes.
there's statutory, we don't have. I could get behind the path that Jeff is suggesting for us in terms of demonstrating our numbers to them. It doesn't say, even if they are going down that path, it doesn't hurt to, even if it is out of our control, it doesn't hurt to solidify our position.
Well,
with
and the
them.
legislature, meets next week and does its final votes, and then the governor it would also be something that would be in the package that would be for the governor
would
staff
review.
would review as well.
Jeff, are those numbers something that we have?
Yeah, we can have, I would estimate, right, I didn't mean to not answer your question directly, Jeff, but I
That's
would
all right.
estimate we probably had about 3 or 4 people denied licensure in the last 3 fiscal years.
Would you be able to put together a document similar to this?
Absolutely.
And how many of
Within
those?
the next week, maybe?
And how many people with criminal background did get a license? And that's kind of the ratio thing, right?
Well, the ones that we actually filed charges and where we did deny license and they've exercised their right to have a hearing, you're always going to be the last
Right.
decision maker on that. You're going to get the proposed decision or the stipulated settlement for the board. So you guys know about that. There are some individuals who the staff denies, and they have 60 days to submit an appeal to us, and there are some people that choose not to file an appeal. And I wouldn't include those people in what I would say the denial as far as this goes, but I mean, they are somebody who is,
Yeah.
it just doesn't even exercise their right to an appeal.
Yeah, so.
And those are few and far between nowadays.
Yeah, so like what I'm implying is that there's column 3 and column 4. One says the number that applied with criminal history identified, and then the number that were denied with that same criminal history. And that gives us that percentage of denial, right? 30%.
Yeah, virtually any of the applicant cases that we open up, there is always going to be it's going to be open up for criminal history. I mean, there may be a couple exceptions out of that, but virtually every applicant case that enforcement looks at is always because of criminal history. So that data we would be able to get.
So today, I mean, one thing, a proposed course of action would be to ask the board to put together this information, which I would find interesting. And then would we send that to the authors of the bill and
I don't know.
the governor?
Do we want to
the
look at
powers
it
that be?
first?
Do we want to look at it first, in which case it would be?
Because in that one, I think it would be more important that all of us have a look at it before it went on.
But then it won't make the deadline, right? Because you're trying to turn around in a week?
The legislature, well, let's look at the legislative calendar again, which is at the beginning of the section. The last day to amend a bill on the floor is tomorrow, and the last day to pass the bill is next Friday. And then the governor, September 30th is the last day for the governor to sign or veto bills passed by the legislature. So the last day to amend is tomorrow. We wouldn't make that. There may be some information that could get to the floor by the 31st, but it's too late for an amendment. But it could be considered by the governor.
But it could be, okay, if we can't, okay, in terms of the legislative path, it doesn't stop perhaps the board staff coming back to this board with that information in October, just simply because we want to be clear on our position if we were ever asked. Certainly we have to go with whatever legislatively is approved, that's not what I'm indicating, but at least we know our numbers and could talk from a real substantial place. I don't know. And if it doesn't seem difficult to do, I guess I would be asking, I'm not just trying to send you down a path of, asking
It's
boards.
not an impossible task. I mean,
Yeah.
it's going to take a little bit of work, but I mean, we can get it.
I mean, and we would have time to notice a special meeting of the board, I would think, if we wanted to review it between now and, not between now and next Friday, but between before the September 30th. I mean, I don't know how that would work. Our council would know more about that.
That means that.
But there's no chance to amend it by the 31st, so I'm not sure that it would be. I don't know. But we could hold a teleconference meeting to review the information in early September, or we could try to see if we can get a special meeting before next Friday. I don't know what your thoughts are on that.
Doesn't seem like they're gonna amend it anyways.
Well, and I want to be clear that my comments were to indicate that, but I wonder then if what we're moving to is, as a board discussion around how we interpret what they're legislatively telling us we have to do.
Well, also, we're advisors to the governor in a way. We're part of the Department of Consumer Affairs. We've been appointed, most of us by the governor's office, and if we really want to have an impact, we do have that way to advise. It could be an extra piece of information to consider in the executive branch, even if the legislature passes it. Which,
Well, there's other,
is that
the authors of this bill are in the assembly. The person who had the most influence on making the authors consider a modification, though it could be the governor, it's probably the speaker. So if you had a meeting, I'd want to make sure that you include in the meeting with the speaker's staff to say why this is it as well.
So what time, so I'm just
So I don't
thinking of the time frame, Jeff, do you think?
I don't think you have time, but that's, you
Yeah.
know, that's why I said, I think the letter speaks for itself. If you want to give some further information, it's welcome to do. I think it'd be interesting to find out for the next meeting, like Denise suggested, so we understand what the shift is going to be. And that way we have a good understanding of it. But it's going to be pretty tight. I mean, usually if you haven't been having this dialogue already, it's going to be tight.
So we either compile the information or we don't, and then we share it and we don't, and then when do we share it if we do?
Yeah.
These seem to be, to me,
Exactly.
yeah.
Ideally next week.
I mean, I think compiling the information is good regardless of the time frame.
I agree.
I think that I'm getting the
That's what
feel.
my point was, yeah.
And then the question is, do we share it, and with whom and when?
We're not going
Because-
to meet the
You know what,
timing, are we?
when you receive the information, that would be up to your decision. If you want to call a special meeting at that point, go ahead. If you don't, you don't.
We could have a quick conference call in a week or in 15 days or something and discuss it if you want. After, would that give you time to put it together?
I think so.
But shouldn't we
I
have a
don't
letter
think-
by Friday, so they have it?
No, we've
so
already
they have
agreed,
it?
we're not.
Was just
Oh,
for
I'm
sure
sorry.
not happening?
My guess is the governor probably will be taking a lot of action at the first part of his 30-day window to do this. Is my guess.
Yes.
Usually it comes towards the end. They've done research, they've gone back out, they've looked pretty heavily on what's been moved. They'll look at all the proposed unless amended. And so he probably won't be in, you'll have a couple weeks after he, more than likely to make a comment, and him have it still.
Beginning of September.
Him still be able to receive it in time to consider it, I would think. I don't know, is that right? You guys know?
Sorry, say it again.
Though we may not make the deadline, it may pass out of the full Senate. Since it started obviously in the Assembly, it's going to be getting out of Senate. So if it got enough votes to get out of Senate the way it is, and it may be get out in a way that we're not happy with, it goes to the governor's desk. And at the governor's desk, he has a period of time, usually 30 days, to make a decision. And so in the first few weeks, they usually are compiling data and trying to find out all the opposition and all the support and why. And then he'll start making his veto or signature. That means that we're really looking at about 20 days before he starts taking action on any of this. Probably, I don't want to say for sure, but my guess is we probably got 20 days. If he does a report, we then look at it, and we want to make sure that it gets added into the governor's consideration for veto or adopt.
So maybe we could have a meeting in early September to review the votes and the position of the board on the minutes, since there's been raised a question about that. We could have a 1 hour maybe conference call, and then second we could review a document that Jeff has compared that's sort of covers
Follow
this
up with
material.
exactly this
Yeah,
format.
the format. Just some detail. Does that sound like a good plan, or does that?
Just one other thing to throw out there. One of the things that was discussed within DCA Legal Affairs was that it doesn't hurt to send a letter similar to the one that was already sent to the author directly to the governor's office. And I don't know how fruitful that would be, and I also don't know how how the previous opposition letters and support letters that may have been directed to the author get transmitted to the governor's office. Even if they do, it might not hurt to direct one directly to the governor's office in advance. So another thing to think about.
And it would probably need to change since the legislation's changed a little bit from when our letter was written.
But you could just provide the letter that you supplied then and just say, for your information, here's the letter that was provided to you, and not modify it, realizing that there's been some modifications. You could do that. The only problem with doing that, again, is at the beginning of our discussion, we talked about that wasn't the letter that we believed was supposed to be sent in the first place. And so it would require us to send a letter now where there's some discrepancy between the board members of whether that was the letter that should have been sent in the first place. That's my only concern.
Yeah, I sure.
Well, that's a done deal at this point, so what we need to focus is the future, to make sure that the governor knows, or whoever's making the decision, that we're still opposing it, and this is the reason why I'm backing documents.
I agree with that. I just didn't
So,
want anybody to.
and that should happen as soon as possible, so it's not too late.
Right. Does somebody want to make a motion?
I'm looking at the ledge info page. It looks like it was ordered to third reading on August 17th. And then and I don't know precisely what it means, but then it says that the file date is today, and I don't know if that means it's going to be read for the third time today. That I'm not sure.
File means, is that full Senate vote?
Right.
Yeah.
It's scheduled for floor hearing today.
So maybe we'll be voting on it today.
In which case, it probably would not
It's a much more
be
difficult house to
that
get out.
fruitful
just
to
to
offer
say.
amendments, because I don't
No.
think it could be
No.
amended after that. It might have some impact to, as you say, sort of, get some of the, compile some of the statistics that are similar to what you see in here to indicate what would or would not be the impact to the board if it were.
So let me make a stab at a motion. And that motion would be to check to ensure whether this letter had also been CC'd to the governor's office. If not, the letter that was sent on June 19th should be forwarded to the governor's office for consideration should the legislation get out of the Senate with an approval.
I'll second.
We have a motion and a second.
Yes.
Any board discussion?
Can someone, I'm sorry, can someone just restate specifically what we're voting on?
What we're doing is we're voting, my motion, we're not voting yet because we're going to have public comment, but when we do get to public voting, unless there's an amendment again, is we're going to vote to send this letter as basically information to the governor's office if we find we hadn't already sent it. There's no CC on it, but there is a CC on it, so it doesn't look like it was sent. So more than likely, we would be sending this letter as an information to the governor's office of our opposition and why. So we are assured that with the full packet that goes to the governor for consideration, he's reading at least our letter saying that we oppose and why. Though there may be modifications, that isn't important. His people would be tasked to see if they've addressed all those if he agreed with them.
Do we want Jeff to read back the motion?
Sure.
I've got check/send to letter dated 6/19, whether it's been forwarded to the governor's office. Should this legislation get out of the Senate?
Senate. But I guess you could just say out of the legislature.
Okay.
Can I get clarification? So there'd be, because what I understood you say before, there'd be a reason as to why the board is saying it still has its position. So there'd be a new letter, but enclosing the June 19th letter?
I guess you could.
Okay.
I thought it'd be simply with an FYI, because I thought we'd take longer to explain all the different reasons why, and then we'd have to go back and look what they've amended, and make sure that it didn't amend it the other, on the floor today, because they could have technically amended the floor today. Yeah, just basically say that the information is why we amended. We could even highlight the main reason is that we should be excluded because we believe we've done a good job of ensuring only those that are most.
So were you asking to have the information compiled to include in that letter?
No, there's no way we can have that. I'd like to get the letter out as soon as possible.
Should the cover letter reiterate the position? Or just say, here's the position letter that we sent to the legislature?
Yeah.
I think it can. I don't think it can hurt.
Okay, so we have a motion and a second. Further board discussion?
Yes.
Oh, sorry, just discussion.
Whoever speaks for itself.
This was an email.
Do you,
This is a majority.
do you want to think, do you have some more discussion?
No, sorry about that.
No,
I
it's
was
okay.
just getting clarified.
No, it's okay. I mean, that's what this time is for.
So the letter is stated? No, good to go.
So, public comment before we have a vote? Heather? Kristen? Okay, hearing no public comment, shall we vote?
Okay. Beata?
Yes.
Denise?
Yes.
Jeff?
Yes.
Sharon? Yes. Richard?
Yes. Motion carries. Now, do we still want to compile the information?
Yes.
That would be another motion, because that didn't include, that's not included in this.
You need a motion for that?
Or do we just instruct staff?
Just to, you just instruct.
Do we want to have a meeting to review it as a board before, sometime in early September? In case we want to send it somebody to see, I mean, who knows if we do or not.
If it's something significant, if the results are substantive, yeah, that the whole board.
We'll see how it
Yeah.
goes,
When I
kind of thing.
compile it, I can send it to you, and then you can figure out. which
So
one.
I'll just figure that out, you guys, and we'll ask for a meeting if it makes sense. Yeah.
That's good.
Okay.
All right. Very good.
Sounds
Why don't we
good.
take, we no longer, let's take a break. Let's take our lunch break now. Let's adjourn for lunch. Since Jeff has got his conference call and it's 12:05. And we'll reconvene at 1:15 after lunch.
You might want to tell them
Thank you.
what's before us. You might want to tell them what's really left on the agenda in case they don't. We only, the rest of all the legislators.
Do you guys have the agenda? Yeah, so you're familiar with what's coming next?
So you'll be coming back?
So you're coming back? Okay.
Cool. See you at 1:15.
August 23rd, 2018 meeting. Welcome back. We just are getting back from lunch. There are a couple of things that have been added. One is a disciplinary action to consider at our closed meeting, which we have not seen before. And I appreciate getting that in. Thank you, Noreen, for bringing that. And then there's a memo that Reza distributed. Do you want to introduce the memo?
Sure. So the memo has to do with item number 16 on the agenda regarding the board's ability to accept the surrender of a license. And so it looks at the law relating to the board's authority to do that and a few related issues. And so take a look. It doesn't answer every question that's out there on the subject, but gets the conversation started. And I believe we're discussing it tomorrow.
Mm-hmm.
That's right. And I would encourage everybody to read it. I read it. I had a chance to read it ahead of the meeting, and it's very full of information. So that'll
Thank
be
you,
it.
Reza.
Yeah. So we'll talk about it tomorrow. Thank you. Getting back to item number 9, we had 7 pieces of legislation that we were discussing, 3 of which we finished discussion on. We saved some of the OTA bills for later because we have the time after lunch. Hope you don't mind. So item number 9C is AB 2221, the Occupational Therapy Practice Act revision legislation. In our packet, you will find the letter of support, if amended, from CBOT. The August 7th version, the August 7th version of the July 2nd version of the legislation, sorry. The legislative information page, which says that it was read a second time in order to a third reading on August 7th. And the third reading materials. And then there was a memorandum from the Board of Psychology, a fact sheet. And my understanding too is that there was another version of the bill that went in on August 22nd. Which we don't have here. We don't have a copy of that, the August 22nd version of the bill, do we? Okay. I happen to have read it online, but I don't. We don't have it to discuss in the full board. The August 27 second version. I probably should have. Anyway, so
Oh, so we can't see the amendments?
we can't see the current version of the bill. Perhaps we can ask for public comment and ask our representatives from OTAC and AOTA about the current status of the bill to start with.
Sure. I did write to a few folks earlier asking what version you had versus what's available. My understanding is the most current version will be available in print to the public tomorrow, actually. So you're not alone.
Yeah.
But I can tell you we were present, both associations sent representation to the Board of Psychology meeting last Friday to a productive end. They had initially voted oppose unless amend, and which got changed to support with the amendments. All the amendments were made that were agreed upon with that board, as well as, I don't have readily available in my mind the list of other groups. We were asked by several groups, the marriage and family therapists, to put exceptions to their practice. All of those amendments have been made.
I believe there's a licensed clinical social work
Correct, that's one.
and MFTs and
All
clinical.
of those were met. Changes with psychology were discussed. So to my knowledge, there's no existing opposition at this point, given all the amendments have been met.
The only thing I would add to that is it was a productive meeting, respectful meeting with the psychologists, and we're glad that we were able to address their concerns.
Are the changes reflected in this July 31st memorandum from the California Board of Psychology, which
In
suggested
part.
amendments?
In part. There is the one part of that memorandum that talks about removing the word psychosocial. That turned out to not even be a discussion point from the board meeting with them. I mean, that memo was generated, I believe, by someone in their office, doing their due diligence. But so the term psychosocial didn't come up at all, although we went ahead and addressed it anyway during our time of speaking to the issue. What was more kicked around was how the language talked about providing mental health intervention. Please don't quote me on these exact words, but there was a lot of discussion about the word functioning versus occupational performance, and that was replaced somewhere specifically, right? That we took the word functioning out at some point.
It was
and put in
changed
occupational performance.
to OT, the language that it, and again, don't quote me, but the language was changed to occupational therapy supports occupational performance.
That's correct.
As opposed to what's originally in the bill.
Yeah. Their biggest concern seemed to be, they actually used the phrase hang a shingle. Like at some point, there was a lot of very rich description given from the public people present on behalf of OT about what our education and training is, what we do. There were discussions about, case examples, that kind of thing. But ultimately they said, we of course value what you do. We feel like, several of them said, we feel like we do understand what you do, and we value what we do. But their concern seemed to be that the language seemed to imply that we could be very independent mental health practitioners, like open an office somewhere and do like psychotherapy, even though the psychotherapy wasn't in there. And so that was the thrust of the concern, is what I would share. And so that got hammered out a little bit by changing some of the language and putting in the amendments I asked for.
They
Okay.
were also, part of that discussion also was, especially the public members made it clear that their obligation, just like it is yours, is to protect the public. And they wanted the public to understand that OTs cannot do psychotherapy. They can't lay you out on the couch and ask you why you're depressed. And they were concerned that some of the language especially about mental health treatment, could be misinterpreted by the public about what exactly OTs do and what their function is and their training and everything. So they were very focused on the consumer protection side of things. But again, many of them, I would reinforce what others said, expressed respect for the profession and said, we understand what you do, we love OTs, we work with OTs, but our obligation is to protect the public.
How did you respond to that specific comment about psychotherapy? Because we know we don't do psychotherapy.
I think it was the witnesses who were there simply, maybe I'll turn it over to Jamie.
I believe a couple of people licensed and we know we don't do psychotherapy, that's true. You know, I think there was largely a lot of collaborative agreement, and so they gave space. It was remarkable in the sense that they were actually past that agenda item when the OT folks who wanted to speak to it arrived, you know, because you know how agendas go with meetings like this. So it got a little changed around, but they still gave them time. What was most remarkable was they also chose to take the time to do some collaborative problem solving because they knew the timeline was tight. Any remaining amendments have to be in by tomorrow. And so out of respect for that timeline, they kind of hammered it out with us. And came up with
And
language
what's coming out tomorrow is a result of that meeting, okay.
correct.
May I ask about our two amendments? Because last time we wrote this letter, which was the date was, there's no date on this letter that we have in here, the position of support if amended.
It's on page 2.
June 21st.
June 21st. So the June 21st letter, we mentioned two things, that there was some language that was proposed to be entered but hadn't been entered yet on educators. Some language that was including how educators should be licensed, and then the removal of that. And that is in this current version of the bill that we have, I believe, in front of us here on July 2nd. And is that language the same in the newest version of the bill?
Oh, yes. Your requested changes went in on July 2nd, that's correct, and remain.
Okay.
Yeah. So your amendments are in, what psychology asked for ultimately was in, and then all the exclusionary people got in, meaning what OT is not.
Okay.
Licensed clinical social workers and all that.
And the new language will be out on the website, on OTAC
Tomorrow.
I
website tomorrow?
don't know about the OTEC website, it should be the legislative site.
The legislative site.
Yeah.
I think it might already be there because I thought I saw it when I looked at it.
You do?
Or maybe I saw a proposed version. I can't remember. Anyway. All right. Any board discussion about our position or any action?
Are we able, just because of the timeliness of it, this is a point of clarification, are we able to, since this is already an agenda item, to bring the wording back, to bring what's on the legislative website tomorrow back just for a look with this board?
You're saying once the amendments are released on the legislative side tomorrow to bring them back, but it's taking a look at them tomorrow.
Yeah, are we able to do that because
Can we
it's
push
on-
it off to tomorrow's agenda, add it to tomorrow, move it to tomorrow's agenda?
And it's a question to
Look.
you setting the agenda, and it's a question to you as a point of fact, can we do it?
As far
Are
as
we
my
able?
part, I think you can.
Well, yeah,
Just
actually.
because we're here, I was thinking.
Yeah, a lot of our materials have had to come to the public anyway today because because of the ADA accessibility rule, which is a newer rule. So some of our stuff hasn't been posted because it's not not ADA accessible. So we're working on that, and that's why a lot of the stuff is coming in on the last day, or on the day of the meeting. Excuse me. If the board wishes to see the text tomorrow, we could ask staff to try to print it out in the morning and bring us a copy if there is. And we could just push this on agenda. I mean, we already discussed it today, but can we discuss it tomorrow as well? Is that kosher to do?
I see nothing wrong with it.
Okay, all right. So yeah, why don't we add it to tomorrow's agenda? Then they'll have to come back. No, but
She's got paper to degrade. This is serious.
no, but we could discuss it tomorrow if you'd like to see the
Just because we're together.
Do you feel, because you feel like, I mean, we had a letter of support if amended, and you want to think about,
I would just like to see the conclusion
Okay.
of all of it coming together. It could end up being a 5-minute
Okay.
agenda item,
okay.
or it could be 30.
I'm just being mindful of our guests, and if we're
We
gonna,
have meet for an hour tomorrow.
If we're gonna
That's
change
10:30,
anything-
I have to leave for the airport.
10:30. If we're going to change anything, then if it's going to make a difference in maybe taking an action, then we probably should. we could do
Well,
it
the
tomorrow.
public members who were part of that committee, she just identified she's here till 10:30.
Perfect. So that'll
So-
work out. So we'll move this AB 2221 to tomorrow.
Thank you.
Sure. First thing on the agenda. Second, the next item on the agenda then would be AB 2386. Services credentialing. Services credential with specialization in occupational therapy or physical therapy services, which the board supported. Do we have an update on that legislation from our public members? Or public, not members, public, does the board want to discuss it first, or should we just ask?
I mean, the main thing I can tell you to a great sense is, you know, it's dead for the year. The membership of OTAC and other interested parties plan to continue to pursue it. It's still a two-pronged approach with both the credentialing group as well as through perhaps new legislation that will bring forward again. I mean, it's got a lot of support. It supports the future of practice. I mean, I think you know the history of it and its intent largely, right? My understanding of the opposition is that and this is just my perspective as an individual, is that it largely is coming down to a lot of different messages about regarding union representation and what a shift in items for these school-based therapists would mean for maintaining their existing pension plans and other things like that. So the OTAC perspective, honestly, is to try to get out and, through education, help people make a decision quite honestly, less fueled by emotion and fear and threats, which is the perception of some, that they fear they'll lose, you know, if they have so many years in service, they fear they'll lose their pension or whatever, if their whole item shifts from one representational body to another. And I'm not sure, I personally don't know enough about how school systems work to really speak to that myself, but I do sense that maybe there isn't as much threat as some people think there is. So the OTAC perspective is to try to get after some of the actual facts and share information so people can make informed decisions. But a lot of the resistance came down to what the unions were presenting in terms of what it would mean for people to shift from this kind of employment item to this kind of employment item.
And it's a 2-year bill?
Yeah.
Will be carried over to next year? Okay.
Yeah. It's at the end, isn't it? I'm not sure.
Any
We'll
board,
check.
thank you. Anything from you, Kristen? Any board discussion on that item? Thank you. Hearing none, let us move to E, AB 2483, indemnification of public officers and employees antitrust awards. According to our legislative information sheet, it was sent to committee. The hearing was canceled on June 26th. It was canceled at the request of the author. So that seems maybe to have. Anybody have any additional information on that bill? Seems to be no activity on that bill. Any board discussion on that bill? Any public comment on that bill? Hearing none, we'll move on to item G. 9G, Senate Bill 1348, PAN, Post-Secondary Education, Allied Health Professional Clinical Programs and Reporting. Moving across to that. G. We have a letter of support from the Occupational Therapy Board. Two things about these letters of support. There's a missing S at the end of the letter, or at the end of the page, Occupational Therapy Assistance, and there was an extra S in our letter of support for one of the earlier bills. So anyway, just proofread the letters would be nice. So it should be Occupational Therapy Assistance at the bottom of the page, I think. It was placed in suspense, appropriation suspense file on June 26th, or 27th, so it looks like that one may also be on hold. Any other information, any other board discussion on that one? Hearing any public comment? Hearing none. We have completed item 9 except for what we're going to discuss tomorrow at the beginning of the day on AB 2221. Item number 10. Legislative items for future meeting. Board may discuss other items of legislation in sufficient detail to determine whether such items should be on a future board meeting agenda or whether to hold a special meeting of the board to discuss such items pursuant to Government Code 11.125.4. Does anybody have a legislative item to discuss at a future meeting? There's a lot of legislation happening, so. Any news? Board members? No? Any public comment on any legislation that you're aware of? Hearing none? We could move on to item number 11 on the agenda. Discussion and possible action on ad hoc committee on fieldworks report to the board on alternative approaches to increasing the availability of fieldwork sites in California for students completing academic requirements for licensure. I'm going to hand this off to Sharon Pavlovich, the chair of the ad hoc committee, to report on the meeting.
Well, I always like to, thank you very much, President Buchalter. I always like to acknowledge the members that are on it, my colleague Jeff Farrow, Michelle Paralise, Ada Boone-Harrell, Joyce Fries, and Matt Leger all met. So we had approval of the minutes. And Jeff, please jump in at any time. Okay. Sure. We still continue to discuss this, as Richard, President Buchalter had said, the discussion and exploration of accepting apprenticeships and alternative approaches to increase the availability of fieldwork sites in California for students completing academic requirements for licensure. Business and Professions Code 2570.6, and consideration of possible recommendations to the board. So we had a lot of handouts and a lot of discussion about where OT is currently being utilized, and all the state offices that use OT. Our executive officer, Heather Martin, reported that a grant proposal was approved from the California Community Colleges Chancellor's Office to gather workforce data for occupational therapy, and that grant is worth $65,000 in funding available. So that was approved, and that's going forward to collect some workforce data, which is exciting. Also, our EO said that the Centers for Excellence are going to administer the survey for the workforce study. The survey will include a postcard mailing, QR codes, website link, and a call-in phone number. So in continuation, Mrs. Heather's been working really hard on collecting data and networking and talking to people, which makes our job on the committee much easier. She said too that we wanted something simple, something short and sweet that people could contribute information to. So it looks like the survey will be about 7 questions or less. It include items like good safety practices, clinical reasoning questions, critical thinking questions, soft skills, professional behaviors, what people are looking for. And she hopes to have a draft of the survey prior to the next Fieldwork meeting, which we haven't yet. We don't have a date for that. Okay. Heather also clarified, Ms. Martin, that both OTs and OTAs would be asked for the workforce portion of the survey, but only OTs would be asked to assess the skills of new grads and OTAs because they are ultimately the supervisor. Ms. Martin stated that the survey will have room for the practitioner to identify up to 3 different jobs or practice areas and the number of hours spent on each. And so our members, Ada Boone-Harrell suggested a professional communication question be added. Michelle Paralise suggested an acceptable documentation be added. And Ms. Martin clarified that these questions were related to the assessment of minimal entry-level proficiency. The committee members submitted additional questions they would like to see on the survey: how long it took to get hired, how long does it take to get hired after graduation, and if they include that, they can choose to delay their search and job offers, or if the job offers are declined. We have, let's see, Mrs. Ada Boone-Harrell reported that she and Jim Collins, Dean of the Science and Allied Health at Sac City College, is very supportive. He actually wants to pilot the program. He's enthusiastic regarding the discussion, looking at infrastructure. Ada Boone-Harrell and Jim Collins have a really nice relationship, and they're really looking forward to seeing if this goes forward, that they can actually, like I said, pilot, kind of get the first additional data for what this might look like. We were supposed to meet, but I think that meeting was canceled because we couldn't get everybody on board. The recommendation from the committee was to continue moving forward with collecting more information and more data, since we have the grant for the workforce study in progress. And I think that's coming at our next, that's supposed to be to us before October, correct?
Sure.
So we can report that at our meeting.
We actually, I mean, we went more than just recommending we go forward. I think we recommended specifically that we actually approve the development, as a board, that the board approve the development of a pilot program to start to see what it would look like as a whole. Because there were so many things going that we're going to be feeding and concluding at the same time. If we waited to that, it would just extend it out further. So the idea was, by giving some kind of approval, then that school that's already willing to start developing a pilot program for maybe a couple students is willing to start doing that. But they're looking for the board to approve a pilot program. And like you said, that data should come out soon. The survey will be going out soon. The purpose of the data was to try to address what so many facilities of higher education struggle with getting funding, is to have proved need, because the data that they use to show that there's need for additional expansion of occupation in the current way that it's provided doesn't, it shows that we've already exceeded what they thought we needed. Mm-hmm. And so they think this new way, this questionnaire and the things that we're doing will show that clearly what people see that are in the profession, that there isn't a sufficient number, and that the direction people are going is we won't be able to satisfy the fieldwork needs as it's currently structured. So creating a pilot and using the state.
Were you looking for a motion today?
We're on the pilot, creation of a pilot, allowing for the creation of a pilot.
Was it for today?
Yeah, it was on. It was.
It's what it says here. But
So I make a motion that we allow for the creation of a pilot between SAC.
Unanimously.
Do you specifically want the names of the program, or specifically between SAC Community
Or-
College and
Well,
the motion wasn't made that way.
accept their recommendation?
The recommendation.
I make a motion that we accept I'm going to rescind that. I'm going to rescind, I'm going to start again. Make a motion that we accept the recommendations of the ad hoc committee on fieldwork.
do we have a second?
I'll second.
Be out of seconds. Board discussion. I have a question about what the board approved the development of a pilot apprenticeship program for OTs compared to the fieldwork means exactly. Is it a statement of support? Is it a?
Yeah, I think I think what the school's looking. They've obviously spent. At least that school has taken very seriously the discussions that this committee has been following, this ad hoc committee has been doing, and believes that because they are involved in some other alternative apprenticeship work and some of the information that's been provided on being able to possibly utilize already state occupational therapists as part of this training, that it's worth it to them to put the energy into doing that. And so I think our thought was, if we approve it, then they can come to us with what their plan is, and we'd be further along. If we don't, they don't want to probably spend the money continuing down the path without having some guidance that we would entertain the idea of a pilot.
And I think since Jim Collins from Sac City and Ada Buchnell have a history of working together and also working with similar apprenticeship programs, they're ready and on board to go, looking for guidance as far as input on what that might look like. But in order to get to all those steps, they just need to be able to approve going forward with the pilot, so then we have further dialogue on getting the workforce data together, what kind of questions, and how would this sample pilot program look like.
So I will say that Ada, you know, I've seen Ada, you know, be very thoughtful and cautious on some of her stuff. She came to the last meeting very excited based upon the enthusiasm of the college and the commitment of time. Her concern has always been being able to get the sufficient time necessary to really put the curriculum and the plan together to execute. And she felt that she had gotten complete approval of whatever she needed to do to make sure that the curriculum fit on the type of needs we would need to have developed. So it was like, well, we should probably then get moving this ball forward as a committee, an ad hoc committee, so we can, we can start to line up when the data comes out. We have a test that can run through that, using that data, and then make a determination after they've run through a student or two, whether it makes sense for a bigger, more approved way to provide the education. So.
Other board discussion?
That's okay. You're excited.
I just have a question for legal. Is there any, do you have any feedback on board issuing a statement of approval for the development of this? Would it obligate the board in any way that we can't foresee? Do we need to, is it okay? I'm just,
Yeah,
I just want
it's a
to
big shift.
clarify what it means to us to do this, if there's anything more than meets the eye.
From that alone, nothing really comes to me, but I suppose ultimately depending on what the statement says, it's worth a second look at that point, but no, on that alone, nothing.
The other discussion I can give you, not based upon this meeting, but it's about other stuff I do in my regular
Sure.
world, is that the state is very anxious to look at new and alternative types of apprenticeship for the state. There's some legislation that's been moving to try to let that happen outside of the traditional building trades model. So I think by doing this as a board, we set ourselves up to be able to participate in a more meaningful way in those discussions on creating something that's tailored more to the health sciences and stuff like that than would be traditionally a building trades. So.
And I think it's been nice to see that, we're discussing alternative options, and it kind of funneled down to, well, the apprenticeship model looks like the one we're going to go forth with as far as piloting. It's still open for discussion, because that might work, that might not. But, I think the consensus of the committee was, well, we're not going to know until we try it, and then we can't explore the other options until, there's already some funding, so this is the first step that the committee decided to go.
Great, so it's an encouragement to move forward.
Yeah.
All right.
Other clarifications?
So we have a motion.
We have a motion.
We have board discussion.
We have a second. We've had board discussion. Is there no more board discussion? We can ask for public comment. None? Hearing none, shall we vote?
Sure. Beata?
Yes.
Denise?
Yes.
Jeff?
Yes.
Sharon? Yes. Richard?
Yes.
Okay.
Motion carries. Very good. Any other report, anything else on that from your committee that you want to discuss at this time?
No, just thanking the whole ad hoc committee. They're amazing. They really, really are.
They are, you are. Very good. So that brings us to closed session. At this time, we have some cases that we need to hear in closed session. We're going to move into closed session. We will ask our members of the public to leave for that. And then we will reconvene for a brief period of time, just long enough to adjourn.
Motion to adjourn.
Motion to adjourn at the end of the day, so there should be no substantive material covered at that time, but you're welcome to come back at that time if you wish.
Thank you for coming. We appreciate it.
Thank you
You're not
both.
adjourning for the day.
We come back to open session and then adjourn.
Correct.
Isn't that right? Isn't
Right,
that,
right. I'm sorry, I
that's-
thought I heard a motion to adjourn.
No, we were explaining to the public.
Oh, I see, okay.
Yeah. If they wanted to come back to see that motion to adjourn, it's really exciting.
Oh, yeah.
I did.
Real fireworks.
Yeah. I'm glad are we all came up?